The Rules Committee will come to order. This is a time when, through our work, we can truly tell the people we represent that help is on the way, and that starts today. First, help for our workers through the consideration of HR 842. Many people have been working too hard for too little in this country for a very, very long time. The Protecting the Right to Organize Act will strengthen workers' ability to stand together and to organize for better pay, for safer working conditions, and for stronger benefits. Second, we are also providing help for communities to combat gun violence through consideration of HR 8 and HR 1446. Gun violence is an epidemic that has robbed people of their safety virtually everywhere they go, from movie theaters, schools, and concert halls to their own homes. It is estimated that 100 Americans are killed with guns every single day in this country. Sadly, it seems that no place is safe. That's why, although most Americans can't seem to agree on much these days, they agree on the need to combat gun violence. Democrats, Republicans, and independents all want to see action on this, and today we are delivering. These bills will close loopholes and strengthen our background check system, reasonable steps that 90% of the public agrees with. Both bills were passed last Congress. We now have a Democratic Senate and a Democratic president, and I hope we can finally make these reforms a reality. Couple these measures together with what we will consider as quickly as possible this week, once we receive it from the Senate, the American Rescue Plan. That is a historic bill to help our nation crush the COVID pandemic. This is truly an exciting time for the American people and all of us who have pushed so hard for so long to tackle some of our biggest challenges. Now let me turn to our distinguished ranking member, Mr. Cole, for any remarks that he wishes to make.
Thank you very much, Mr. Chairman. Today's hearing covers 3 items, and I'd like to start with HR 842, the Protecting the Right to Organize Act, which, if signed into law, would be the single biggest change to our labor laws in 80 years. The majority selling HR 842 as an update to the National Labor Relations Act, but it's more accurate to call it a union boss wish list. At every turn, the bill prioritizes union bosses over workers and businesses, and at every turn, it stacks the deck in favor of unionization. Before I continue, I want to be clear that I support the right of employees to join together to form a union if they so choose. What I am not supportive of is allowing for tactics of intimidation, placing a thumb on the scale to prioritize the interests of union bosses over the interests of employees who choose not to form a union, and overturning the laws in 27 states who do not force unionization as a condition of employment. Consider just some of the provisions in this bill. HR 842 removes protections for workers who choose not to share personally identifying information with union representatives. It also imposes a nationwide so-called card check scheme that would force a workplace to unionize upon receiving signed cards from 50% of employees without a secret ballot. Without personal protections and without a secret ballot, these 2 provisions make it all the more likely that workers will be harassed at home and at work until they agree to sign a unionization card, whether they truly want to or not. But the bill doesn't stop there. It preempts every single state right to work law, which protect workers from being required to become members of a labor organization or to pay fees to one. 27 states, including my own home state of Oklahoma, have such a law. The bill also changes the joint employer standard, overturning a decision of the National Labor Relations Board and making millions of employees as franchisees nationwide subject to this standard. And it reimposes an Obama-era rule allowing for the creation of micro-unions, which would allow a unit smaller than a workplace to unionize. At every turn, this bill prioritizes union bosses over workers. I think the House should take a long, hard look at the ramifications of this bill before voting on it, and I think the majority should rethink this scheme. Our other 2 items concern background checks for those seeking to purchase or transfer a firearm. HR 8 would impose new requirements for a background check anytime a gun owner wishes to purchase or transfer a firearm, and would effectively criminalize gun transfers or sales without government permission. HR 1446 imposes similar restrictions. It's aimed at expanding background checks and would accomplish that goal by changing the existing 3-day background check period to a period of 10 days. But if that background check is not completed within 10 business days, the person wishing to purchase a firearm must file an appeal, which can then take up to another 10 business days to process. This will inevitably have the effect of interminably delaying a person from buying a firearm. Mr. Chairman, the net effect of both these bills is only to deprive law-abiding citizens from exercising their Second Amendment rights while doing little to prevent mass shootings or to prevent those who should not possess firearms from purchasing them. While Republicans are not opposed to screening prospective gun owners, it's important to note that the federal law already covers many of the concerns these bills are intended to address. There are already limits in federal law making it illegal to transfer firearms to individuals barred from possession, and it is likewise illegal to purchase a firearm for someone who cannot legally have it. Nothing in these bills would prevent wrongdoers from acquiring firearms. Republicans have proposed legislation to prevent mass shootings. During the 115th Congress, Republicans passed into law the Fix NICS Act, which ensured that the NICS system used for evaluating potential firearm purchases has up-to-date and accurate records. Last Congress, Republicans proposed the Mass Violence Prevention Act, which would create a Mass Violence Prevention Center within the Department of Justice, but Democrats blocked it from coming to the floor. These proposals represent real solutions to the problem H.R. 8 and H.R. 1446 are intended to address. That Republican proposals would do so while respecting the rights of law-abiding gun owners and ensuring that wrongdoers cannot acquire firearms. I would urge the majority to rethink their present path. There are alternative solutions out there. We need not embrace the draconian proposals of H.R. 8 and H.R. 1446. Rather, if we work together, we can come up with real bipartisan results for the American people. With that, Mr. Chairman, I yield back.
Thank you very much. The gentleman yields back. I'd now like to welcome our witnesses to provide testimony on H.R. 842, the PRO Act. Chairman Scott and Ranking Member Fox, we are delighted that you're here. Without objection, any written materials you submit to rules.documents@mail.house.gov before the conclusion of this hearing will be entered into the record. I now recognize the gentleman from Virginia, Chairman Scott.
Thank you, Mr. Chairman. Ranking Member Cole, I'm pleased to speak to you today on H.R. 842, the Protecting the Right to Organize Act of 2021, better known as the PRO Act. I want to start by noting that the House has passed a substantially similar bill last year after the committee held 3 legislative hearings and a markup where 35 amendments were debated. In the 1950s, nearly a third of all U.S. workers were union members. Today, it's just over 10%, the lowest level since just after the National Labor Relations Act, or the NLRA, was enacted in 1935. This decline is not a result of workers' choices. Polls consistently show that about 50% of workers would like to join a union, but intensifying and well-funded anti-worker attacks have stripped workers of their voice. It is plainly obvious that the NLRA is too weak to defend workers' basic rights to join a union and collectively bargain with their employer. The PRO Act makes the most significant upgrades to the NLRA, as the ranking member has pointed out, since it was established 85 years ago. These upgrades achieve 3 overarching goals. First, the PRO Act provides new tools to protect workers from anti-union intimidation and retaliation. Then it introduces meaningful penalties for companies and executives who violate workers' collective bargaining rights and closes loopholes they use to exploit workers. And finally, the PRO Act strengthens the safeguards to ensure that workers can hold free, fair, and safe elections. Democracy in the workplace should be a right, not a fight. This legislation is grounded on the simple fact that when workers can stand together and form a union, they can negotiate higher wages, better benefits, and safer working conditions. Thank you, Mr. Chairman. I yield back.
Thank you very much. Ranking Member Fox.
Thank you very much, Mr. Chairman, and Ranking Member Cole, for the opportunity to speak in opposition to H.R. 842, the so-called Protecting the Right to Organize, or PRO Act. I'm experiencing a bit of deja vu. Once again, my Democrat colleagues are rushing a radical piece of legislation to the floor without one committee hearing or markup. And my colleague from Virginia, whom I like and respect very much, has said it's substantially similar. You know, that doesn't mean exactly the same. We also have many new members on the committee who've not had a chance to be a part of the discussion related to this bill. Is this the new standard for the People's House? Rush sweeping one-sided legislation to the floor without debate and thereby silence members of the minority in an effort to hide the truth about the Democrats' socialist agenda? There are nearly 24 new members on the Education Labor Committee, and their constituents deserve to have their elected representatives examine this dangerous bill. And let's not forget that since the Democrats last introduced this bill, a federal probe uncovered almost a decade of rampant corruption among the senior ranks of the United Auto Workers Union, including money laundering, tax fraud, bribery, and embezzling workers' hard-earned union dues for lavish personal expenses, leading to the conviction of 15 union officials. The bill before us makes union bosses more powerful, but less accountable to workers, increasing the risk of union corruption and wrongdoing. I cannot in good conscience call this bill well-intentioned, but I can call it the Pro-Union Bosses Act. And that's apologies to my good friend, Norma Torres, who I know does not like that term. But I love Norma a lot. This far-reaching radical legislation is nothing more than a union boss wish list aimed at rewarding Democrats' big labor allies at the expense of American workers. Union membership in the U.S. has been decreasing for over 60 years and continues to plummet due to the modern economy and the union's own failings. So I certainly disagree with my colleague from Virginia on the point that he made. It isn't the failure, it isn't companies trying to stop unions from forming, it's the workers understanding the failings of the unions. But instead of increasing transparency and accountability to serve their members better, labor union leaders are demanding House Democrats pass the PRO Act to tilt the scales in their favor. Democrats are doing exactly that, no matter the cost. If it was only a matter of being fair, then we wouldn't do away with right to work states, because that would give people truly the freedom to choose what they want. I'd like to remind my colleagues that federal law already protects the right of employees to organize, and Republicans respect this right. But any reforms to U.S. labor laws should help workers flourish in the modern economy. Unfortunately, the extreme bill before us today helps union bosses at the expense of workers. As the party that claims to champion the working class, Democrats have certainly missed the mark with this bill. H.R. 842 will force employers to hand over workers' private, personal information to union organizers without workers having any say in the matter. That is not freedom. This would make it even easier for union organizers to target, harass, and intimidate workers. H.R. 842 would also overturn all state right-to-work laws. These 27 state laws allow workers to decide for themselves whether to join a union and pay dues. Again, it's taking away the freedom whether to join a union or not join a union. If the PRO Act becomes law, workers will be forced to take money from their paychecks and give it to labor unions, even if they don't want to be represented by a union. This is astonishing, since we know that from 2010 to 2018, unions spent $1.6 billion in member dues on hundreds of left-wing groups, such as Planned Parenthood, the Clinton Foundation, and the Progressive Democrats of America, without consulting their members. The PRO Act will also undermine workers' right to vote by secret ballot by imposing a biased card check scheme in which workers could be unionized without the union winning a secret ballot election. Every member of Congress is elected by secret ballot, and House Democrats elect their own caucus leadership by secret ballot. Yet they want to deprive American workers of that same protection by passing the PRO Act. The bill also deprives individuals of entrepreneurial opportunities, the ability to set their own hours, and the flexibility to care for children and family members by creating burdensome and discredited legal standards for determining joint employment and independent contractor status. The PRO Act means the elimination of the franchise industry and sharing economy as we know it. Mr. Chairman, I've submitted 3 amendments to the committee, and I ask that they be made in order under the rule. The amendments are intended to stop union violence, protect workers from union corruption, and prevent workplace profanity and harassment. These modifications will help safeguard the rights of workers in the workplace and are common sense provisions which should enjoy bipartisan support. Bottom line, this bill is shameful, and so is the process under which it is being considered. H.R. 842 is radical, backwards-looking legislation which will diminish the rights of workers and employers while harming the economy and providing a political gift to labor union special interest. We're better than this. I yield back.
Thank you very much. I appreciate both of your testimony. I want to ask unanimous consent to submit to the record a statement of administration policy on HR 842. And let me just say that, you know, I strongly support organized labor. I always have. Unions built the middle class in this country. Many of the worker protections that are enjoyed by non-union workers were won by hard-fought battles led by organized labor. And any suggestion that somehow companies are not using every tool and every dollar that they have to try to kill organizing movements, I think shows a removal from reality. I mean, the deal is that it is very hard to organize a union in the United States of America. And it has become even harder. And yeah, we have some laws on the books, but for the last 4 years, we had an administration that had nothing but contempt for working families and had a lax administration of those laws. So I think this bill is long overdue, and I strongly support it. I now turn to Mr. Cole for any questions he may have.
Thank you very much, Mr. Chairman. And I will note for the last administration, they managed to give us the highest standard of living and the lowest unemployment rate in 50 years. So I think that's how you care for American workers. You create job opportunities for them. And my first question is to you, Dr. Fox. Federal investigations have uncovered almost a decade of rampant corruption among senior officials of the United Auto Workers Union, including money laundering, tax fraud, bribery, and embezzlement. As I read this legislation, it appears to me to be a union boss's wish list. Can you clarify some of what you see as the most concerning of the so-called reforms that this legislation intends to advance?
Thank you. Thank you, Mr. Cole. You are absolutely right about the rampant corruption that has existed among senior officials in the unions. The PRO Act increases the coercive power of union bosses while undermining the rights of employers and workers alike. First and foremost, the bill overturns all state right-to-work laws, meaning workers will be forced to pay hundreds of dollars per year to a union, even if they do not wish to be a part of the union and would prefer to represent themselves. Right to work is one of the only ways workers can hold union leadership accountable, and the PRO Act eliminates it. In addition, the bill compromises workers' privacy by requiring that reams of their private personal information, including home phone number, cell phone number, home address, personal email address, and more, are shared with the union organizer without allowing workers any say in the matter in order to make it easier for unions to target workers, and there are no safeguards for how this personal information will be used or protected. We all know that people are very concerned these days, particularly about how their personal information is being used by various organizations. This would be a rampant violation of personal privacy. Finally, it's important to note that unions attempted to organize less than 0.1% of eligible employees in 2020, with a similar figure in 2018 and 2019. So rather than dedicate more of their focus and resources on trying to organize workers, they're demanding their allies in Congress enact this radical coercive bill, which makes it much easier for them to organize. They worked for this majority in the Congress and a Democrat president, hoping that that would make it easy for them. And it will if this bill passes.
Dr. Fox, again, I'm fearful that the majority's, so-called reforms, which again empower union leadership disproportionately, will make it tougher on small businesses to operate effectively as well. What are some of the biggest concerns that you have in terms of this legislation and how it affects, employers in general, but particularly smaller employers?
Well, this is going to go after all businesses, but particularly small businesses who do not have the mechanism for educating their workers as to the liabilities of being members of unions. Larger companies will probably be able to do the education they need, have the legal representation they need, but small businesses will not be able to do this.
Let me turn to you, Mr. Chairman, if I may. Americans are used to using secret ballots to elect members of Congress. Democratic caucus uses secret ballots to elect your party leadership. We do the same with ours. In fact, Democratic leadership actually fought tooth and nail to delay the USMCA agreement until Mexico agreed to secret ballots when voting on organized labor. A good thing, in my view, by the way. So I find it ironic this legislation looks to break away from that system and move to a card check system, which is ripe for fraud and abuse. Can you tell me, why the change of heart now? Why shouldn't American workers be able to have a secret ballot, not rely on this card check system?
Well, actually, they do. The present law and longstanding precedent allows the employer and the union to agree if the union has shown support through card check and just agree to the union with nothing more. And so that's been present law. The change in the law is that you can go to card check rather than an election when the employer has committed unfair labor practices and corrupted the election. Then you can go to the card check. But it's so long as the employer is not committing unfair labor practices, then the secret ballot maintains.
Dr. Fox, do you have the same view?
Absolutely not. The PRO-Act's backdoor card check scheme is one of the most concerning provisions of this bill. The PRO-Act would eliminate secret ballot elections for workers in many instances and allow the inferior card check process to be used instead to recognize a union. It permits this process by allowing unions to lob unfounded accusations of unfair labor practice charges and forces employers to prove their innocence rather than requiring the charging party to prove an employer's guilt. That is the backwards way from the way we operate in this country. You don't have to prove your innocence in this country. The accusing party has to prove your guilt. The NLRB would then be the judge, jury, and executioner. So not only does this dangerous provision eliminate the rights of workers, it does so as well for business owners. It's really a shameless process. It is undoubtedly one of the worst parts of this bill.
Chairman Scott, your version of the PRO Act from 2019 included what I think all of us honestly would agree were important whistleblower protections, but they appear to be absent from this bill. Would you support the inclusion of those protections, which I think Ms. Henson from Iowa has offered an amendment to that effect?
I think there's several amendments to protect whistleblowers, and I think they will be considered as amendments, and we support those.
Thank you very much. Dr. Fox, would you care to comment on whistleblower protections as well?
Well, again, this bill does very little to protect workers who do not want a union. It just does not do that. And so what we want is for there to be right to work states and the true ability for workers to decide whether they want to be in a union or not be in a union. And everything is stacked against businesses and against employees that don't want to be members of unions.
Thank you very much. Thank you, Mr. Chairman. I yield back.
Thank you very much. Ms. Torres.
Thank you, Mr. Chairman. I wasn't planning on saying anything, but I must say that I was inspired by my good friend, Mrs. Fox. I have to push back a little bit on this, and for the record, I was never a union boss, but I have been a union member for almost 20 years. I grew up in a union household. And my husband was a member of the building trades for over 20 years. So, with that as background, I want to say that, union boss is not the correct term, because union members are elected, duly elected, to represent themselves and their organizations that they oversee by the membership themselves. I volunteered as a shop steward for my local ASME 3090 in Los Angeles, and we had to challenge management and sometimes our own union, on occasion. I won every single claim that we brought against management because they were in the wrong. Being in a union allow workers to correct the wrong as a unit instead of as individuals. I mean, there's a case to be made for why we have not been able to raise the federal minimum wage in 12 years. Many workers remain working in conditions that are we would not expect to treat computers, for example, the way we treat subhumans workers. So, all workers deserve to have a voice. But while, we're talking about the issue of worker representation, and while we are celebrating Women's History Month, we cannot forget about the unsung heroes of the 911 dispatchers. We continue to deny them a hearing on the 911 Saves Act, a bill that would recognize their work as first responders, their critical work as life-saving individuals in 911 centers across our country. We need to move away from the ill-conceived secretarial job classification that they currently work under, and we cannot continue to look away simply because male-dominated industries are still stuck in the 1950s. I support the PRO Act because it brings unions, to where we are right now, the current day, where workers deserve to be respected for the work that they do. So having said that, Mr. Chairman, I do support this, the PRO Act. And I have to say to my colleague, Virginia Fox, Mrs. Fox, that maybe some of those old, style union bosses are the reason why, I continue to support labor, but it's not a two-way street because I was not supported by labor in my last election. So with that, I will yield back.
Thank you very much. Is Dr. Burt, I don't see Dr. Burgess. Okay, then I will go to Mr. Rushenthaler.
Thank you, Mr. Chairman. I appreciate it. I have no questions at this time, and I would yield back. Thank you.
Thank you. Mr. Perlmutter.
Just a couple points. I support the PRO Act. I really think it's about the freedom to choose without the threat of intimidation. And having been a member of a union for a long time, that exists and that happens. So that's the main reason. And I've served with the gentlelady, Mrs. Fox, for a long time now. And I know the more time she uses adjectives, adverbs, and hyperbole like radical, rampant, coercive, because I listen closely because I respect what she has to say, but I know when she uses lots of adverbs, adjectives, and hyperbole, the weaker her case. So I would just yield back and support this bill.
Thank you. Ms. Fischbach.
Thank you, Mr. Chair. Ranking Member Fox, here's another piece of legislation that we've got that's not moving through the regular process and hasn't received a hearing in committee this year. And, I understand it's very similar, but you mentioned in your opening remarks that you have a lot of new people on the Education Committee and in Congress that didn't have input on this bill as it goes to the floor. And I just wanted to give you the opportunity to give us a sense of what improvements or changes to the legislation Republicans would have offered if the bill had been, if you'd had the opportunity during markup in committee.
Well, I'm not sure the Rules Committee wants to be here that long today. Number one, well, first of all, let me say before I answer your question, and don't forget to do this, that in reference to what Representative Torres said, I don't believe that everybody who works with unions is vile and corrupt. Obviously, that's not the case, but we certainly have plenty of examples. And this bill would have given us an opportunity, I'll tie it into what Representative Fischbach is asking. This bill would have given us an opportunity to root out corruption. What we all want American workers to be treated fairly. That is the bottom line. We all have that value. We go about it in a different way. But when you have the examples of union bosses abusing the workers they're supposed to represent by stealing their money, using it for personal purposes, that's definitely one of the things we would have done something about. We want transparency. We want accountability. Every time I've been before this committee, you've heard me talk about accountability. Whether we're spending the taxpayer dollars or the leaders of the unions are spending their union members' dollars, it should be for the purposes that they are giving it up. And that would have been one of the main things we would have changed. We worked in the last administration on accountability in many, many different ways, and we would have continued that. And that in itself would have made this bill a lot better. You know, my friend Earl, my friend Ed, I always want to call Ed Earl, and we've talked about this before, but Ed said what he wants is the freedom to choose. This bill is the opposite of the freedom to choose. If you had the freedom to choose, you wouldn't do away with right to work states. That indicates, when he says I'm using adverbs and adjectives because my case is weak, I think just the opposite. I think if you were not afraid of the freedom to choose, you wouldn't do away with right to work states. Why in the world do you have to do that? If the unions were really popular and really were being denied membership because of existing laws, then you wouldn't have to go to the radical extreme of doing away with right to work states. I go back all the time to this issue of freedom. This country was built on freedom. And when you take away freedom, either the government gets bigger or the unions get bigger. Whatever unit you're giving the freedom to from the individual, you're taking it away from the individual. You're making the individual smaller. That's not what this country's about. And I'll continue to fight on that issue. So I would just say transparency, keeping right to work, strengthening whatever might need to be strengthened, but you don't do things like firing the NLRB general counsel in the first week in office when the person still has 8 months to serve in their term. All of the scales are being tipped dramatically toward unions. If it was really freedom to choose, as the representative from Colorado says, then you wouldn't have to do all those things. So let's make it freedom and let's focus on that. So thank you for the question.
Thank you very much. And thank you, Member Fox. That was very brief in the.
You need to unmute, Ms. Fishbach.
Up. I'm sorry. I was just commenting that I thanked Ranking Member Fox, but also explained to her that that was very brief under Rules Committee standards. So I appreciate it. I've only been here a short time, but I have learned that. So, but Ranking Member, you had one more thing you wanted to add, or?
Well, I want to say the reason it's very brief, as my colleagues will know, I sat in your seat for 4 years, and then I sat up near where Ranking Member Cole is sitting, right next to the chairman, when I was vice chairman of the committee, and I value brevity. And I think Mr. McGovern appreciates that on my part particularly, and I hope all the other members do too.
Well, thank you, Ranking Member Fox, and thank you, Mr. Chair. I yield back.
Thank you very much. Mr. Raskin.
Thank you very much, Mr. Chairman. And I also am a very strong supporter of the PRO Act, and I'm also delighted to see my friend, Ms. Fox, who seems to have galvanized the attention of the committee this morning. I want to start actually by asking you, Ms. Fox, about this question of freedom, because my understanding of the labor movement is that freedom was the organizing principle of the labor movement, the freedom to organize, to engage in collective bargaining, and not to be subject to different kinds of judicial sanctions that companies would get, to stop picketing, to stop organizing. And there was a conflict between the freedom to organize and the freedom to fire people who were organizing. So I'm just wondering where you come down on that fundamental question. Do you think people have a freedom to organize a union, or do you think that the employer has the freedom to fire people who organize a union?
Oh, no, Representative Raskin, I believe people have the right to organize. I think all Republicans believe that. That's a fundamental freedom in our country. Oh my gosh, his name's gone out of my head, but the famous Frenchman who came and toured our country in the 1800s said, who said this country was a country of associations. And I'm amazed at the number of associations we have. If he came back now, he would be amazed too. So certainly the freedom to organize is there. That's why we think this bill is unnecessary, because that's already there.
Let's pursue that for a second, because one of the provisions I like very much in the bill is the one which says that it's an unfair labor practice for the employer to herd all of the workers into a room and then show them anti-union propaganda in order to stop a union organizing drive. And that's already illegal when it comes to presidential elections, where employers are not allowed to herd everybody in a room to say, you got to vote Republican or you got to vote Democrat or whatever. That's an unfair labor practice in the election context. It's a violation of FICA. Do you agree it should be an unfair labor practice for employers to coerce workers into participating in anti-union propaganda sessions?
Well, one person's propaganda is another person's education. So I'll be very careful about the terms that we use. You know that, Mr. Raskin. You're an attorney. You're much more skilled at doing these kinds of things than I am. But when I go out and talk to employers, I'm very clear on that. I often say to them, and they'll say to me, we cannot tell people how to vote. And I will tell them that, and I'll say to them, however, there's nothing wrong with explaining to people what are the different philosophies in our parties. And so, again, I think that it's very fair to explain. I mean, I recommend giving out the platforms of the different parties, but the terminology you use, you know, Mr. Perlmutter says I use very loaded terms, but herding people into a room and you're saying propagandize them. Yeah, you know, you might invite people to, I'd say it, people are invited to come into a room to
Well, if it's
learn
voluntary,
about
well,
different
yeah.
philosophies. So it depends on how you say it.
And I think that is the critical question, whether it's voluntary or not. And, you know, the reason I support the PRO Act is because it's all about protecting the freedom of workers to make a decision on their own and not being coerced or manipulated by people who control their paycheck, who control the workday, and so on. Workers have always fought for the freedom to get to make that decision on their own. And, you know, let me just ask you one other point, because I always value your insight so much. You know, we started with an attack on certain unions that have been corrupt or corrupt union bosses. Undoubtedly, that's true. Would you agree that there are corrupt corporate CEOs who engage in insider trading, who engage in embezzlement, who abuse the rights of workers, who sexually harass? Would you agree that for every union boss you can find who's done something illegal or unethical, you could find a dozen corporate bosses who've done the same kind of thing? And therefore, that doesn't translate into a condemnation of all unions any more than that would translate into a condemnation of all businesses.
Well, I wouldn't say that there are 12 corporate heads to one union boss.
Well, there are a lot more corporate heads than there are union bosses.
If you don't give me that ratio, I will agree to you there are bad apples in any organization. There are bad lawyers, there are bad members of Congress, there are bad teachers, there are bad doctors. And I've said that all my life. It's usually a small percentage, but certainly we can find corruption everywhere in this country.
It's a small percentage among the labor union leaders who, after all, are accountable to the workers. And in fact, a lot of the labor bosses who've gotten in trouble are ones who've been corrupted by the companies. They've kind of gone over to the other side and have been, you know, bought off by the businesses and stopped representing the interests of the workers. But all right, and thank you so much for your answers and your insight. You always liven up our proceedings when you come, Ms. Fox. I just want to ask Mr. Scott, if I could come to you for a second, about the PRO Act. You know, why is it time, do you think, historically, to right the scales? I mean, you started by talking about the decline in union membership. How do you trace that to the legal architecture and the rights of workers in the workplace?
Well, first, a lot of comments have been made about this bill tipping it towards the union. Actually, it's just untipping it away from the corporations who have been able to, as you have indicated, coerce, require people to be subjected to anti-union propaganda. They've also been able to fire workers who organize with virtually no sanctions. There's an old adage that says the nail that sticks out is the one that gets hammered. If someone is identified as a union organizer and gets fired, the sanction that the employer will suffer, if the NLRB imposes the sanction, which is another problem, is back pay, minus what the person was able to earn on the side. So if the person gets fired and needs to pay his mortgage and gets another job earning essentially the same as he was earning, there is no sanction. This bill allows for meaningful sanctions to give some deterrent effect to firing people who are trying to organize. We've heard a lot about the fact that you have to join the union. There's nothing in this that says you have to join the union. It does not override right to work laws. You don't have to join the union. You do have to pay for the benefits that you derive from union representation. The law requires the union to represent everyone equally, including individualized representation. If a non-union member gets fired or has some situation where they need individualized representation, if they would represent a union member, they have to give the same level of representation. They have to hire the same number of lawyers, spend the same amount on lawyers and everybody else to represent that non-union member as a union member. The non-union member gets the pay increase that the union members paid for with accountants and lawyers to negotiate safe workplace benefits and everything else. All this requires is they pay their fair share for those expenses that the union was required to, by law, to provide to the workers. Now, that means it's not required to pay for the proportionate share of the summer cookout or the holiday parties or the political activities, but for those activities which the law requires the union to provide, including individualized services, just their fair share. And you've also heard a lot about corruption and the convictions that were had. That shows that the process works. The corruption was discovered. The people were prosecuted. And during the Trump administration and during the prosecution, there was never any suggestion that new tools were needed to prosecute people. They said the tools were there. The guilty people were prosecuted, and if the law needed to be changed to make it easier to prosecute, easier to discover, I'm sure the Trump administration would have made some recommendations. They didn't, and so I don't. A lot of the criticisms are just criticisms, as I indicated in my closing. The legislation is grounded in the simple fact that when workers can stand together and form a union, they have higher wages, better benefits, and safer working conditions. That's a reason to vote for the bill. And I guess that's also a reason to vote against it.
So, Mr. Chairman,
if you don't agree with that.
Mr. Chairman, let me ask you two final questions about it. I want to go to this whole question of a secret ballot, where some of our colleagues were suggesting that the legislation would overthrow a secret ballot. And believe me, having just come back from the US Senate where we were conducting the impeachment trial of Donald Trump, I would have loved to have had a secret ballot over there, because we probably would have gotten 90 votes, I think, to convict the president, or at least that's what we were being told by the senators. But in any event, we obviously don't always have a secret ballot. But as I understand this legislation, it doesn't impair a secret ballot in any way. If there is a union election called, it's totally pursuant to the pre-existing rules under the NLRA and the regulations under it. It is a secret ballot. This is simply to say that if a majority of the workforce wants a union in advance, they can file cards attesting to that fact, and then those cards can be turned in. Is that right? Am I reading that correctly?
No, they can be turned in, and if the employer agrees to accept that as evidence, then they can voluntarily accept the union. That's present law.
Oh, okay. So
the difference is that if they if they have the cards showing majority support, and the employer corruptly, illegally sabotages the election, that you can use the cards as evidence to form the union.
Okay, I thought that the current law was that an employer who violates the rights of the workers and commits an unfair labor practice can be required to recognize the union if there was a majority card check. Isn't that right?
That's right. Well, that's what's in the bill. You can voluntarily except the employer can voluntarily accept the card check. And it's over. But what this does is just if there is an unfair labor practice where the election, where the secret ballot election was corrupted by unfair labor practices, the union can show that it had the support through the card check and proceed from there. But if the employer is not committing unfair labor practices, then you have then you go through the normal secret ballot.
Okay. All right. And finally, you know, I think that the best of the labor movement has always been about advancing the democratic rights of the workers to have an association in the workplace to fight for their rights, and not just wages and benefits, but the right to participate and the right to help make the workplace more efficient and more effective. Interference with that right to organize is a violation of a civil right. And I think that this legislation recognizes it as a violation of a civil right that would give people the right not just to go to the NLRB to try to, you know, get an unfair labor practice declared and to get injunctive relief against it, but also to go and sue and say, you're violating our civil rights. Is that right? Am I reading it correctly?
Right. Right now, if there's an unfair labor practice, you go to the NLRB and get them to hold the employer accountable to the extent of the law. And regrettably, as I indicated, the extent of the law isn't much under present law. What this does is allow a private right of action that you can go and vindicate your own rights.
Okay, and that's sort of how anti-discrimination law works generally, right?
It's how most laws lie. If your rights are violated, you should be able to go to court to have your rights vindicated.
Okay, I yield back, Mr. Chairman. Thank you very much.
Thank you. Ms. Scanlon.
Thank you. And thank you, Mr. Scott, for bringing this really critical legislation to the Rules Committee. You know, ever since the Industrial Revolution, labor organizations and labor unions have been vital parts of our economy, found in every sector, and they've been the key driver for so many of the workplace rights we take for granted today, whether it's the 40-hour work week or ending child labor in this country. Organized labor is driven by the fundamental right of workers to have a safe place in which to work, a fair wage for that work, and a dignified retirement once that career is over. For decades, Democrats and Republicans were firm believers in the power of that union. That power gave us American middle class and provided so many of us in this body the backing and support we needed to get to where we are today. My mother and sister are union members. My father-in-law, all my brother-in-laws. But you know, that's what set our family on a solid middle class background, and you know, me, my children, everyone in our family, the ability to move forward. But over the years, we've seen that support has waned. We've seen big business invest heavily to diminish the labor movement through well-funded and organized attacks, selling workers on false promises that they themselves would be better off without the invaluable protections provided by their unions. Workers have been pitted against each other, knowing that corporate interests would ultimately win out. And boy, have they. The rise in anti-labor laws have tilted the balance further and further. We've seen an exponential growth in income inequality. The fact is, if any party wants to call themselves the party of the working class, they have to support efforts to genuinely help American workers. And that's exactly what the PRO Act does. It gives a voice to the working class and sends a message that we as a Congress support workers in their efforts for workplace rights and fair wages. My district was built on the union labor and labor movement, and it's strong today in the greater Philadelphia region. But we've seen people slipping. We've seen that the average family now in my district is underwater at the end of the month because they have to pay rising healthcare costs, housing costs, and childcare costs, and their wages have remained stagnant. So I really believe that this is really important legislation. The American people aren't looking for handouts. They're just looking for a fair shot. And I think this bill is going to help provide that. Representative Scott or Chairman Scott, can you talk about how a strong and accountable NLRB can benefit the lives of all Americans, not just those who are part of the labor unions?
Well, a lot of the things you said that we have benefited from are enjoyed by people who are not unions. If you are a union member and negotiate a decent wage, safe workplace, and retirement benefits, the non-union employer down the street competing for workers, as the workers recognize what the union members are getting, and as soon as an opening comes up, all the good workers will run to get a good union job. The employer, the non-union employer, therefore, has to compete for workers, has to increase his wages, has to have a safe workplace, has to talk about a retirement plan. And so if you're not, even if you're not in a union, the fact that a union is in the area tends to increase wages and working conditions everywhere. There's also an expectation that people get these better wages. And if you don't have a union and nobody's negotiating for wages, that effect doesn't happen.
You know, you seem to get workers at the table with more bargaining power, obviously, against powerful corporate interests. But what about women and minority participants in labor unions? I mean, these are folks who are excluded in other ways in our society. How can unions benefit women and minorities?
Well, there is a pay gap that is well known. Women and minorities get paid for equal comparable work, get paid less, and that's just a phenomenon around the country. However, in a union contract, everybody gets paid the same. If you, whatever your job classification, if you're in that classification, women, minorities, everybody else, equal pay for equal work. There is no wage gap, and people get used to paying equal pay for equal work in a union contract. That's one of the major benefits of being in a union. You don't have to worry about getting less pay.
So that helps inclusivity.
Right.
Okay. Thank you.
Thank you. Mr. Morelli.
Thank you, Mr. Speaker. I apologize for being late traveling here, as a result, I'll probably repeat a couple of things that my colleagues have said, so I apologize in advance. But I'm struck by just the interesting dialogue we've had in the committee over the last several weeks, which I think highlights sort of just a question of values and what we value here in Congress as we begin our work in the 117th Congress about what's in the interest of the American public. You know, we had a debate just a few weeks ago at the minimum wage, and I continue to be mystified as to how folks in year 2021 could suggest that a wage of $7.25 an hour should be appropriate given the cost of living and the fact that we have this fight about that, and now the question of whether or not individuals ought to be given the opportunity to organize and, in my view, exercise First Amendment rights of assembly and gathering together. So I think this does highlight the difference in values, and as my colleague Mary Gay said, you know, this is what helped build the middle class in the United States. I have, like many others, union members in my household. My wife was a teacher for many years, a member of the union. My members of my family. My dad, unfortunately, dropped out of high school in Utica, New York, and if it had not been for the opportunity to join the pipe fitters union and plumbers union back in the late 50s when he returned from Korea, I'm not sure what kind of life we would have had, but he had the opportunity to rise from an apprentice to journeyman and specialized in pneumatic controls, things I can't even tell you what they did. but he was there and he worked very long hours. I don't think I ever saw my father in the morning. He was already off to work. 6 o'clock, 6:30, he'd be out the door at work in freezing temperatures on top of buildings. And people suggest that somehow union workers don't work or somehow that you're not putting in your fair, your day's work and have a right to be able to be heard at the table about what those wages ought to be, what those benefits ought to be, what working conditions ought to be. I find it mystifying. And you only really have to look at what's happened over the last 25, 30 years, and frankly, since we've been gathering these statistics. Back in 1983, I think the first year they tracked this data, 20% of Americans were members of unions, if you were wage and salary. That number is essentially cut in half. In 2020, it was 10.8%. It varies for public and private sector, but it's clear that it is dramatically reduced from where it was when we first started calculating this data. But if you look at the average weekly median, the median wage, weekly amount for union workers, it's $11.44 a week. For non-union members, it's $958. If non-union people made what their union brothers and sisters made, they'd see a 19% increase in their wages, not to mention what their benefit package would be. So it strikes me as odd, what factor would lead people to be union members by almost half the percentage they were when we started looking at the data. And yet it's a dramatically better lifestyle because gathering together and organizing together for wages, for benefits, for working conditions puts you in better stead. It's because we've tipped the scales, that we put our finger on the scales as government, as a matter of public policy, to make it frankly more difficult for people to organize. We've allowed employers, and look, I'm a Democrat who cares about economic development. I care about innovation in the workplace. I care about entrepreneurship. I think the American dream is to pursue whatever it is you want to pursue. That's what we all are about. I didn't become a pipe fitter. Somehow my career got off sideways and I got to Congress instead. But everybody should be able to pursue what they want to do, but they ought to have the right to gather together and organize. And in the way that people can aggregate capital, they should be able to aggregate labor. And I think this bill reestablishes the appropriate balance. My hope is it will lead to more private sector union membership because it means a raise in wages. We've seen that. You see that, the data everywhere. And I appreciate too, Ms. Scanlon, asking about women, asking about people of color who have higher rates of membership in the unions, but still lag far behind on wages as a national number. So I think this legislation is important. I'm going to support the rule. I obviously support the underlying bill, and I want to congratulate and thank my colleague and my chairman. I have the privilege of serving on the Education and Labor Committee, and I do appreciate all the hard work that Mr. Scott has put in. And Mr. Chairman, I appreciate you putting this on the agenda early in this Congress to make sure that we make an important statement about what we think of those values, of those American values. And I think this is high among those things that we should value in America, the right to organize. So with that, I yield back.
Thank you. Mr. Desagne.
You're on mute.
You need to unmute.
Sorry, I was teasing Mr. Perlmutter. I just was telling the ranking member that a lot of us have confusion over whether he's Earl or Ed, but so that's understandable. Less understandable is you forgot a great Frenchman, Alexandre de Tocqueville, but I won't be offended by that, Ms. Fox. I just want to acknowledge what you said. This country was founded on freedom, although as we know at that time it was not freedom for everyone, and this country has also had a long troubled history with cheap labor. We know that after World War II, in particular, the economy grew by historic amounts every year, and that's the same time when 1 in 3 workers was in a union. And there's plenty of research that shows that's what fueled it in large part. It was also what created the American middle class. And since Ronald Reagan, we have gone from 1/3 of the workforce when Eisenhower was president to 10%, as Mr. Rowley pointed out. So for me, it's this balance, as John Kenneth Galbraith talked about, is countervailing institutions between the pressure of wages versus capital. And right now we're way out of whack, that capital predominates our economy, which has resulted in this inequality that Ms. Scanlon talked about. So I look forward to voting for the bill. I'm proud to be a co-author. I appreciate the committee bringing it. And I think it's really important, if we want to make our economy grow, that organized labor has an opportunity to have a fair fight to organize. And I say that as somebody who is both a member of a Teamsters local in Massachusetts and a member of the Hotel and Restaurant Workers in San Francisco, and owned a small business. And small businesses don't have the challenge of people organizing if they treat their employees well. Most of the businesses that organize are larger businesses because workers want to have some proportionate say vis-a-vis the capital market. So with that, I just remind folks of a quote from President Eisenhower during that period of time. He said, "Only a fool would try to deprive working men and women, American working men and women, of the right to join the union of their choice." Thank you, Mr. Chairman.
Mr. Chairman, I want to say how nice it is to see Mr. DeSaulnier back and looking so healthy. He's another friend of mine on the Rules Committee, so it's delightful to see him.
Well, I hope you still have that high opinion of him after he handles the rule on the floor.
I'm sure she will, as I will for her. Thank you, Virginia. I appreciate it.
Yeah, we have to set aside philosophical differences at times.
I now want to thank you. I want to yield on to Ms. Ross.
Thank you, Mr. Chairman, and it's so good to see my colleague, Representative Fox, back here with us. In the interest of time, because we have a few more things on our agenda, I will not ask questions on this particular bill, but get ready for the next one, and I yield back.
Thank you very much. Does any other member of the committee wish to ask a question? Seeing none, I want to thank our witnesses for their testimony, and you are now excused.
Thank you, Mr. Chairman. Thank you, Ranking Member Cole.
I would like to inform the committee that we will hear from any members wishing to testify on amendments to HR 842 at the end of today's hearing. I would now like to call up our next panel to testify on HR 8, the Bipartisan Background Check Act of 2021, and HR 1446, the Enhanced Background Check 2021. Chairman Nadler and Ranking Member Jordan, we are delighted that you are here. Without any objection, any written materials you submit to rules documents at mail.house.gov before the conclusion of this hearing will be entered into the record. I would now like to recognize the gentleman from New York, Mr. Nadler.
Well, thank you very much. I thank Chairman McGovern and Ranking Member Cole for the opportunity to testify concerning two important bills under the jurisdiction of the Judiciary Committee, HR 8, the Bipartisan Background Checks Act of 2021, and HR 1446, the Enhanced Background Check Act of 2021. Since the House passed these two bills more than 2 years ago, an estimated 80,000 people have lost their lives to gun violence. And in the past year, the FBI background check system was overwhelmed by demand, delaying investigations and resulting in a potentially large volume of firearms being transferred before a background check was completed. Clearly, we must act swiftly to enact sensible and effective gun violence prevention legislation. One of the most important things we can do to address this epidemic of gun violence is to require that virtually all gun sales and transfers, not just those conducted by licensed gun dealers, be completed only if the person seeking to obtain a firearm has passed the background check. There is no reason to continue to make it easy for people who are legally prohibited from possessing firearms to acquire them anyway by circumventing the background check process. That is why we must enact HR 8, which was introduced by our colleague Representative Mike Thompson of California to close this dangerous loophole and save lives. It is simply a mechanism of enforcing existing law better. At the same time that we adopt HR 8, we must also enact HR 1446, which addresses a dangerous loophole in the firearms background check system. Currently, federal law allows gun dealers the discretion to transfer firearms to purchasers after 3 business days in instances in which a check has not been completed. If the National Instant criminal background check system called NICS hasn't completed the check quickly, and the vast majority are in fact completed within minutes. It may be due to incomplete or unclear information in records that require additional examination. These are the very cases that ought to be strictly investigated. If NICS is unable to return an instant determination, and especially if there is no report after 3 days, there is certainly cause for concern. One notable example of the tragic consequences of this loophole is that it allowed the shooter to obtain the firearm used in the hate crime murder of 9 people at the Emmanuel AME Church in Charleston, South Carolina, 5 years ago. That is why HR 1446 is needed, to extend the time a dealer must wait before transferring a firearm when the check is not yet finished, while giving a prospective purchaser the opportunity to petition the FBI to complete a delayed check. HR 1446 is a sensible and necessary approach to address this issue, and I commend our colleague, Congressman Jim Clyburn, the distinguished Democratic whip, for introducing this bipartisan bill. I strongly support both HR 8 and HR 1446 because we must do all we can to protect all of our communities from the daily toll of gun violence, and both are urgently needed to do that. I look forward to these bills being considered on the floor this week, and I yield back.
Thank you. Ranking Member Jordan.
Thank you, Mr. Chairman. Mr. Chairman, the bills under consideration today continue the Democrat majority's attack on Americans' basic rights. For almost a year, Americans' First Amendment liberties have been limited. They've been told they can't go to church, can't go to work, can't go to school, can't attend a loved one's funeral. Of course, the rules didn't apply to Democrat politicians. They could eat at a 5-star restaurant with friends and lobbyists, but Americans couldn't enjoy Thanksgiving with their family. Now they're coming after Americans' Second Amendment liberties. Each of these bills is an affront to law-abiding Americans who lawfully possess firearms for sport or for self-defense. When taken together, these bills are an assault on the Second Amendment to the Constitution. H.R. 8, for example, would require a background check for every firearm transfer in the United States with very limited exceptions. And it doesn't just apply to transfers from firearm dealers. The background check requirement applies to ordinary firearm owners, hunters, and sportsmen. It applies whether the transfer is permanent or if you're just loaning your buddy a rifle for his hunting trip. H.R. 8 would turn otherwise law-abiding citizens into criminals simply because they transferred possession of a legal product that each of them are legally allowed to possess. Keep in mind, of course, that it's already illegal under federal law to knowingly transfer a firearm to a person prohibited by law from possessing one. This bill tries to make some exceptions for firearm transfers for hunting or for sport, but these exceptions are drafted and poorly written. Under H.R. 8, while I could lend someone a firearm for hunting, he or she could only use it, quote, while in the presence of the transferor. The bill, of course, doesn't define presence. Does it mean we have to be physically next to each other? Or can we be a couple hundred yards away in 2 different duck blinds? What if we are hunting miles apart on different sides of the same hunting preserve? The bill also allows the transfer of a firearm between 2 law enforcement officers, but only if the transfer is within the course and scope of employment and official duties. So 2 police officers could swap weapons if they're on the job, but those same 2 officers could face 1 year in prison and a $100,000 fine under this bill if they make the same transfer while at home. It's amazing. The same House Democrats who want to defund and dismantle the police also want to take away the rights of our law enforcement officers when they're off the clock as well. What's even worse, H.R. 8 does not cap the dollar amount for what a firearms dealer can charge as a fee for processing a firearms transfer. This could put a high price tag on Americans' constitutional right to bear arms. Imagine what would happen if a survivor of domestic violence wants to borrow a firearm to defend herself when her abuser is released from jail. What if she can't afford the transfer fee? For instance, right here in Washington, D.C., the transfer fee is $125. Imagine if we put such a large price tag on the rest of our constitutional rights. Proponents of H.R. 8 argue it is necessary to stop mass shootings events in the United States. Mass shootings are evil, pure and simple. We all understand that. But every perpetrator of these horrific events either passed a background check or stole the weapons they used. This bill would not have prevented the tragic events in Parkland, Las Vegas, Orlando, or El Paso. While H.R. 8 specifically prohibits gun registries, it is impossible to enforce the bill's provisions without one. Don't take my word for it. The Obama-Biden Justice Department concluded in 2013 that universal background checks are ineffective without a gun registry. Think about it. There are hundreds of millions of firearms in private hands today. Many have been transferred already. How can you prove an illegal transfer going forward without also registering those existing firearms? While H.R. 8 criminalizes harmless and ordinary firearm transfers, H.R. 1446 makes it close to impossible to complete the background check process. H.R. 1446 would extend the current 3-day time frame to transfer a firearm to 10 days. The current 3-day standard is long held. It is meant to put the burden on the government to notify the firearm dealer promptly that the person seeking the firearm is prohibited from possessing one. If the government cannot produce evidence that the individual attempting to acquire the transfer is prohibited from possessing a firearm, the transaction may proceed at the discretion of the dealer. H.R. 1446 flips the burden, requiring the dealer to receive approval from the government before making any transfer. Under this bill, if a firearm dealer conducts a background check and does not receive a response from the government after 10 business days, the purchaser is not permitted to take possession of the firearm. In other words, your constitutional rights are at the mercy of some government bureaucrat. The purchaser may then petition the FBI to permit the transfer to proceed, but the dealer may not proceed with the transaction until an additional 10 business days have elapsed from the date of their initial petition. Keep in mind, these are business days, not calendar days. This is important because current federal law limits the validity of a background check to only 30 calendar days from the date the check begins. Depending on the calendar, there's a real possibility that some Americans could wind up in an endless cycle of application, background check, appeal, and then just repeat it all again. But perhaps this is what the authors of 1446 actually intended. This bill is touted as closing the so-called Charleston loophole that led to the Emanuel AME church shooting. But the provisions of this bill would not have prevented that tragedy. The FBI had 2 months to determine that Dylan Roof was prohibited from possessing a firearm, but they failed to do so. We should be looking to hold federal, state, local agencies accountable and provide them better training, which is exactly what House Republicans did when we passed and President Trump signed into law the Fix NICS legislation back in 2018. Taking H.R. 8 and H.R. 1446 together, Democrats are fundamentally changing how law-abiding Americans can obtain, transfer, and use lawful firearms. Our rights as Americans deserve better than these two bills. Let's also keep in mind that these delays have real-world consequences. In 2015, a New Jersey woman was murdered by her ex-boyfriend after she waited for more than 40 days for a firearm permit. Changing the current 3-day proceed to sale provision would prevent thousands of similar Americans from exercising their right to self-defense. Mr. Chairman, I'd like to note that this is the second week in a row where Democrats will be considering bills from the Judiciary Committee that have not had a hearing or a markup in this Congress. Not only does this deprive our new members of an opportunity to have input in this legislation, but these two bills aren't even the same bills that the House passed last Congress. I urge you to adopt an open rule and allow all our colleagues to offer and debate real policies that might actually work instead of these faulty pieces of legislation. And with that, Mr. Chairman, I would yield back.
Thank you. Well, let me just move on. Let me just say, as somebody who has met with mothers and fathers who lost their children to gun violence in my own district and all across the country, who is tired of hearing them ask the same question over and over, which is, as gun violence gets worse in this country, why doesn't Congress act? Why doesn't Congress do anything? And so I think, this is a values issue, and people can decide to do nothing, which is unfortunately what's happened over the last several years, or people can begin to start taking action to embrace modest, reasonable gun safety measures that may save lives. I mean, that's the issue, and I think people are tired of the talk and are hoping that we'll take action. And In the House here, we will take action. And I hope the Senate follows suit. I'd like to ask unanimous consent to insert in the record a statement of administration policy on both HR 8 and HR 1446. And with that, I yield to Mr. Cole.
Thank you very much, Mr. Chairman. And just note, I mean, any incident of gun violence, we all agree is too many. And we certainly have had some horrific examples, but the longer term trend is actually we have less gun violence than we did 20 years ago. It's actually come down fairly dramatically. Again, I don't say that within any approval of any misuse of a firearm, as I'm sure everybody here would condemn that. But we don't have as much of this, frankly, as we once did. That's a good thing. I've got just a couple of questions, Chairman Nadler, and it may be too narrow, actually, in some ways, but I'm curious about your perspective. On page 3 and 4 of HR 8 refer to the temporary transfer of weapons. And let me just say that gun ownership in my district is very common. It is in most of the rural parts of the country. Probably close to 1 out of every 2 of the households that I represent own a firearm, and it's mostly either for protection or for hunting. But target practicing is pretty popular in my neck of the woods as well. And so this idea that we have the term temporary transfer, that's pretty common in my area. People loaning guns for hunting, or hey, go try this and target practice and see if you like it. It's not unusual. So I'm curious, why was the decision made not to define what temporary is? And because I do have some concern people would do what is, at least in my part of the country, pretty normal practice and then find themselves inadvertently having violated the law. Could you address that and why we left that temporary phrase without a more precise definition? Chairman Nadler, did you hear my question?
Yeah, you need to unmute Jerry.
Okay?
Yes, we can. Thank you.
Okay, very good. Well, Mr. Cole, I think, frankly, the bill allows for what you're talking about. Under 1446, the FBI will have 10 business days instead of the current 3 business days for the initial background check investigation period. It's not a waiting period. The sale can be processed by NICS at any time. Anytime after 10 business days have elapsed, people may, if they want to, submit a petition for expedited review. If such a petition is submitted, unless NICS provides an answer within the next 10 business days, the transfer can lawfully proceed. So someone, and this petition can be filed anytime after the initial investigation period before the destruction of the records. That means that someone could petition on the 25th day or the 45th day, for example. The FBI has a minimum of 20 business days to complete the background check if it can't be completed immediately. That's all 1446 does.
Well, again, I'm talking about temporary transfer, and I have some of the concerns that Ranking Member Jordan expressed in his comments about people that are lawful owners transferring a weapon temporarily or whatever to somebody else who, again, it's also licensed to carry a firearm or use a firearm. Getting caught up. I'll turn to
all this, I think you're misreading the bill. All this says is that someone who may lawfully transfer a firearm.
I'm talking about HR 8, Mr. Chairman, not HR 1446.
Okay, HR 8 provides that you have to have a background check for whoever transfers the gun, not just licensed gun dealers. A licensed gun dealer may be a store or some other kind of business that transfers a gun to an individual, and that's currently subject to the background checks. But a transfer from an individual who is not a licensed gun dealer is not subject to the background checks. And what HR 8 does is simply make those kind of transfers subject to the background checks also?
Mr. Jordan, is that the way you would interpret this legislation? Again, you probably represent a district somewhat like mine. I just have a lot of people that are going to inadvertently end up breaking this law, and be subject to penalty when they've done nothing more than what they normally would do for a friend or for a relative or what have you.
Yep.
Could you comment on that, please?
No, you're right. You're exactly right, Mr. Ranking Member. And I think the chairman was actually mostly referring to the wrong piece of legislation. The concern is under HR 8, they don't define temporary. So you probably have the same experience in rural Oklahoma that we have in, rural West Central Ohio. Thanksgiving morning, you got friends and relatives come in town, and they're gonna go rabbit hunting. They're gonna loan each other their shotguns and firearms to go out and have a hunt together. They're gonna transfer for that kind of hunt. Well, what if they get separated? How is it defined? And I think that's your concern. That's my concern. That should be every American citizen's concern who cares about the Second Amendment. Just that practical problem with this bill, not to mention the overall attack on your fundamental liberties.
I'll give you an example. My brother owns land, and he allows people to come and hunt, friends, people he knows. Sometimes people come and literally borrow a gun to go hunt. He's not going to hunt with them. He's just letting them come onto his land to hunt. Would that be potentially a criminal activity under HR 8?
Yep, sure would. And that's our concern. With, among others, that's our concern with HR 8.
Okay, that's my concern as well. I just don't think it's very precisely defined. I think the courts will end up defining it because we certainly haven't done it in legislation. Nobody knows where that goes. So I just count me as skeptical about legislation that puts people doing what they normally do, where there's no threat, no danger, subjecting them to criminal prosecution. But anyway, that's only one of my many concerns about this legislation. With that, Mr. Chairman, I'll yield back. Thank you very much.
Thank you. Ms. Torres.
Thank you, Mr. Chairman, and thank you to our guests that are here today, bringing these two HR 8 and HR 1112. February of 2019, the House passed the Bipartisan Background Checks Act and the Enhanced Background Checks Act, two very critical bills to strengthen background checks for firearm sales. The bills languish on now Minority Leader Mitch McConnell's desk for 2 years. In the meantime, we experienced a record year, a year with the most mass shooting events in the United States record. In 2020, there were 611 mass shootings. 611, more mass shootings than there were days in the calendar year. If these bills had been passed, maybe, just maybe, we could have prevented some of those horrendous murders. Communities that have experienced violence have been raising their voices for years, pleading with Congress to do something. After 26 innocent children, school children and teachers were killed at Sandy Hook, the community pleaded for action. After 9 people gathered in peaceful worship were gunned down at a church in Charleston, the community prayed for change. After the lives of 17 students, coaches, and instructors were ended at Marjorie Stoneman Douglas High School, the community marched and cried. They cried out for change. These children who watched their friends get murdered, hunted down, and slain are begging for our help. It's time to listen. You know, on the issue of law enforcement officers not being able to, trade in their guns with each other, I would simply say, would the officers that flew across the country and participated in the insurrection that we survived, should they continue to have a gun? Should they be allowed to trade after their gun was, a permit was taken away? Should officers that are involved in domestic violence for beating their wives or girlfriends or children, should they be allowed, after their departments take away their weapons, should they be allowed to trade and get a gun? I would say no. These bills strengthen basic background check requirements and close dangerous loopholes. HR 8, the bipartisan background checks of 2021, simply ensures that everyone undergo a background check before purchasing a firearm. If HR 8 had been passed in 2019, the shooter who killed 7 people and injured 22 in Odessa and Midland, Texas, would never have been able to get a gun from an unlicensed seller because he could have filed a criminal check, background check. HR 1446, the Gun Background Check Time Limit Act, will prohibit a gun sale from proceeding if a background check isn't completed within 3 days, as is permitted under current law. If this would have been the case, been the law in 2015, 9 people praying at a church in Charleston would never have been murdered. So the gunman would not have been able to buy a gun simply because his failed background check was delayed. So enough excuses. It's time to act. And I urge my colleagues to support these 2 critical bills and move them forward. And with that, I yield back, Mr. Chairman.
Thank you very much. I don't see Dr. Burgess, so I will go to Mr. Reschenthaler.
Thank you, Mr. Chairman. Let me first start by just associating myself with Ranking Member Cole's remarks, and also adding that I agree that there are things this body can and should do to address gun violence. One idea is the MVP Act, which would create a fusion center at the FBI to help local, state, and also federal law enforcement share processes, share intelligence, and more effectively respond to potential instances of mass violence. With that said, I'm concerned that the bill before us, I'm speaking of HR 8 right now in terms of specifics, HR 8 does nothing to stop criminals from breaking the law. In fact, all it does is it really just penalizes law-abiding citizens who are simply exercising their constitutional rights. So I don't think that we should pass legislation just because it feels good. We should do it because it actually makes a difference. With that, Chairman Nadler, thinking back to all the high-profile shootings, Sandy Hook, the church in Charleston, the Pulse nightclub, the Las Vegas shooting of 2017, the shooting at Marjorie Stoneman Douglas High School, would HR 8 have prevented any of these high-profile mass shootings?
Well, Mr. Reschenthaler, it's not about mass shootings only. It's about shootings we have every day. And these bills would go a long way. You can't say they prevent them all, obviously, but HR 8 and HR 46 together would go a long way toward reducing the number of people killed by gun violence.
Well, Mr. Chairman, I'm going to get back to the high-profile shootings in a second. But yes or no, are you aware that the DOJ says that 75% of criminals in prison who committed their offenses with a firearm, out of those 75%, only 1% got their firearms from dealers or non-dealers? Are you aware of that, yes or no?
No. You have to understand that people who commit crimes with firearms overwhelmingly obtain these firearms from unlicensed sources. The best evidence indicates that about 80% of all firearms are obtained from sellers. 96.
All right, Mr. Chairman, I'm going to reclaim my time again. Mr. Chairman, I'm going to reclaim my time, but again, I'm just going to refer you again to the DOJ stat that says that 1% of criminals who commit firearm crimes or crimes with firearms, only 1% got those guns from dealers. That's the stats in the DOJ. So right now we're addressing 1% of those crimes you referenced, albeit I'm against those crimes, but we're talking about 1%. Now, going back to the high profile shootings, yes or no, are you aware that the shooter at Sandy Hook murdered his mother and stole his mother's guns? Are you aware of that, yes or no?
No.
Okay. That's what happened. Would HR 8, yes or no, would HR 8 have prevented that shooter from killing his mother and stealing her guns?
Well, you can't say that HR 8 would prevent every single.
Okay, reclaiming my time. So that reclaiming my time, the answer is no. Are you aware that the shooter in Charleston purchased firearms legally from an FFL and also passed a NICS background check, yes or no?
Yes, but the reason for the bill is that the FBI doesn't have the time enough to perform the background checks.
All right, reclaiming my time. So HR 8 specifically would have done nothing to address that shooting. I'm again referencing HR 8. Okay, right, because again, we've already established that he purchased the gun from an FFL and he passed a NICS background check. So again, HR 8 alone would have done nothing.
Not established that he passed the NICS background check, because the fact of the matter is that the FBI requires a certain amount of time to conduct the background check, very often doesn't have it, and all HR 8 does, or HR 1446, is extend the time periods that the FBI can complete the background check, and that.
So, Mr. Nadler, I'm going to reclaim, Chairman Nadler, I'm reclaiming my time just so you know for education. The shooter at Charleston actually did pass the background check. There was administrative error. I will give you that. There's administrative error, but again, HR 8 alone would have done nothing to prevent that. Are you aware that the shooter at the Night Pulse, the Pulse nightclub, are you aware that he legally purchased those firearms and he also passed NICS? Yes or no?
No.
Okay, he did. That's a fact. So again, HR 8 would not have prevented that shooting. Are you aware?
That's not a proper conclusion.
Are you aware that in the Vegas shooting of 2017, that shooter legally purchased his firearms from an FFL and he also passed the NICS background check? Yes or no?
All of your questions presuppose that the NICS background check was accurate, despite the fact that the FBI admittedly does not have the time without these bills to conduct the background checks properly. So they have no proper answer. And you cannot assume that in fact they passed the test.
All right, Chairman Nadler, also, we'll move on here, but the shooter at the Marjorie Stoneman Douglas High School also legally purchased the firearms from an FFL and also passed the NICS. So there's nothing in HR 8 that would have prevented that shooting either. And again, all these shootings are tragedies. The point is that HR 8 would do absolutely nothing to address or to have stopped those shootings. They would just infringe upon the right of law-abiding citizens. Chairman Nadler, can you just, given what I've told you, I think what you're referring to a lot in these shootings, saying that NICS wouldn't have applied, are straw purchases. Is that what you're referencing?
No, that's not what I'm referencing.
So you're basically just saying there is a problem with NICS itself.
There is a problem with an insufficient time period for NICS because the FBI can't do the job and properly certify NICS in most cases without the proper time, and that's what HR 1446 is going to address.
Right, exactly. And we'll talk about 1446, but HR 8 does not talk about that.
Well, actually, HR 8, no, it doesn't. It's HR 1446.
Right, it's 1446, not HR 8. All right, Chairman, I was concerned last Congress when we were bringing this up, specifically, I'm talking about HR 8 now. I was concerned specifically there was no cap on the cost of a mandated background check. So failing to control or to cap this cost represents what really is an unfunded mandate on private citizens wishing to lawfully exercise their constitutional rights. Chairman, why did the majority choose not to cap the cost of a background check?
Because the cost is up to the market. As a good Republican, you ought to understand that the market rules.
Right, as a good Democrat, you would be okay with putting a price control on the background check. Would you be open for that?
I don't think we have to do that. The market rules here, and that's fine. What we do have to do is make sure that unlicensed gun dealers, as well as licensed gun dealers, are subject to the law, which is what HR 8 does. So right now, if you obtain, whether through purchase or gift or whatever, but if you obtain a gun from a licensed gun dealer, you must go through the NICS system. But if you obtain a gun from anyone else, you are not subject to the NICS system, and HR 8 is necessary to fix that.
Yeah, Chairman, I'm going to reclaim my time. Again, I'm specifically referencing HR 8 and the cost of background check. I just think there should be a cap. Your party has already been okay having a cap, even though there's free market principles at work. We can go back to the minimum wage discussion. I don't want to go down that road, but it's weird that now you're talking free market when for the last several arguments, you've completely abandoned free market principle arguments. Chairman Adler, I'm also very concerned about having a national gun registry, which I personally view, and so do my constituents, as the first step to gun confiscation. Are you aware that the Obama DOJ concluded that universal background checks are unworkable without a gun registration? Yet HR 8 specifically prohibits this, and I'd refer you to page 5, lines 18 and 9. Chairman Adler, why can I get you to promise me that you will not come back in here at some point and push for a national gun registry?
No.
No, not at all.
We will not do that.
We will not.
But you do know that Obama DOJ said that if you want universal background checks, you need a federal registry, right?
No, you're misinterpreting what they said.
I can read you the quote at a later time, but that's exactly what they said. So if we pass this bill, we'll be back here passing a national gun registry. All right. Ranking Member Jordan, I want to direct you to 1446. Does this bill do anything to address the failure in law enforcement to coordinate anything that led to the travesty and tragedy that was the Charleston shooting?
No, it doesn't.
Okay. And I am correct that shooter did leave, and I'm not going to say his name because I don't think we should glorify these shooters, and I would ask my colleagues to do the same. But am I correct that this was purchased through an FFL and that individual passed the NICS system, albeit there was a clerical error in NICS?
That's my understanding, Representative.
Thank you, and with that, I yield back my time.
Mr. Perlmutter.
Thanks, Mr. Chair. I've been a co-sponsor of these bills for years now. They're common sense in Colorado. I know I support this, my district supports it, the state supports it, and I think most Americans support both of these pieces of legislation. And I appreciate the gentleman from New York and the Judiciary Committee for advancing this. So Mr. Nadler, Mr. Rushenthaler did a lot of cross-examining there and trying to limit you to yes and no answers. And I'd offer you a chance to expand on some of the things, if you so choose, where you were limited, particularly on sort of the NICS conversation as well as the various loopholes.
Well, as I've said, these are very limited pieces of legislation. NICS is an essential system, but it has its problems. One of its problems is that if the FBI doesn't complete the check within 10 days, the acquirer automatically gets the gun, whereas the FBI cannot complete such a check often within 10 days. And the bill expands that for 3 days. The bill expands that from 3 days to 10 days, which is not overly burdensome on the would-be gun acquirer. The second thing is that the current federal law requires the background checks on licensed gun dealers only. So if you acquire a gun from someone who's not a licensed gun dealer, from someone who's got a sales booth at the county fair, for example, you're not required to have a background check. That makes no sense at all, because the person who's acquiring the gun could be a felon. He could have beaten his wife. He could have done a lot of things that would disqualify him from getting a gun. But because of the technicality, the silly technicality that we currently require only that licensed gun dealers are subject to the law, and unlicensed gun dealers, he'll get away without any check. So this bill simply says, no, you got to have a background check to discover whether the purchaser or the acquirer is a felon or is otherwise disqualified from having a gun, whether or not the dealer is a licensed gun dealer.
Thank you. You know, I mean, I guess, and I probably should mute myself when you're speaking. I'm sorry about that. The thing for me is why anybody but a felon would be opposed to these pieces of legislation is beyond me. And, you know, Colorado, we've certainly shared we've had the mass shootings at Columbine and in Aurora, but we've also had lots of other instances where somebody who would not have passed a background check, you know, was able to acquire a firearm. But since we passed that, we've been able to stop a lot of felons who wanted to get guns from getting them. So that's the purpose. That's the purpose of this.
You're quite correct, and the state data bear this out. When Missouri repealed its law requiring a permit to purchase a handgun, even if the seller was not licensed, precisely the situation we're talking about, the homicide rate rose by 25%.
These are common sense. The last thing I'll say is, we will be taking up again the rescue plan, the American Rescue Plan, which provides a lot of assistance to state and local governments, particularly for firefighters, for police officers, for first responders of all kinds. And Mr. Jordan had a comment about defunding police. The American Rescue Plan funds the police. And from my point of view, any Republican who voted against the American Rescue Plan has voted against funding the police, the firefighters, the transportation workers, the public health officials, the teachers, you know, the people who are on the front lines. And I think that's a major mistake. And it's leaving a lot of people who protect us every day in the lurch. That's what funding the police is all about. And with that, I yield back.
Thank you. Ms. Fishbach.
Thank you, Mr. Chair. I just wanted to touch base. Ranking Member Jordan, Ranking Member Cole had mentioned the temporary transfer and how it was undefined. And I was just wondering, because it seems like there's a lot of terms in HR 8 in particular that are undefined, and I'm wondering, are there other terms, undefined terms that you think would cause particular issue or unintended consequences?
Well, the biggest one is the one, thank you, Representative. The biggest one is the one that the ranking member brought up, this term temporary, and in the very situation that Mr. Cole described, where you have a friend coming to hunt on your land and you're going to let them borrow your firearm to engage in, to hunt that day. That's the biggest concern in HR 8, for sure.
And Ranking Member, I think of, my area where we've got farms, and if someone hands somebody a gun to help them protect livestock from prey or issues like that, they will have the same issue. And so that is a concern for not only, hunting land, but also farming.
Yep. Very possible situation.
And Ranking Member, the bill allows for a transfer between immediate family members, but only if transfers for a loan or a bona fide gift. And so what limitation does this then put on if you simply exchange firearms between fathers, sons, mothers, sisters, whatever the case may be?
Yeah, great point. And I think that's a concern as well. How does that play out when you're talking about, family, close family? Which is again in your part of the woods up there in western Minnesota and mine in western Ohio. those kind of situations would be problematic, I believe, under this legislation, particularly as poorly written as it is.
Thank you. And one final, just moving to HR 1446. And my colleague from Pennsylvania had brought up the Charleston loophole. And it seems to me that the Charleston tragedy was more of a breakdown of communication and coordination than a supposed loophole. Is there anything in this legislation that would better develop those processes to ensure the FBI, local law enforcement, and the AFT are in sync?
No, you've described that tragedy and the situation accurately, and no, there is not in this legislation. I would also point out, back to the cost that was referenced in a question earlier. It's not a market situation, certainly not here in the District of Columbia, because there are no federally licensed firearm dealers in the District of Columbia, because the regulations put in place by the local government are so onerous. So if you do want to transfer a firearm in District of Columbia, it's $125. So that is our concern. Sure, we're for the market, and there is a market in other states, but there is not in the nation's capital, and that is our concern. Think of the other fundamental rights you have, and putting a price tag on those other fundamental liberties. I mean, for goodness sake, that's our concern here. Not that there's not a marketplace, because there is, frankly, in other states. There's just not one here in the District of Columbia.
Thank you very much, and thank you, Mr. Chair. I yield back.
Thank you. Mr. Raskin.
Mr. Chairman, thank you very much. I wanted to just start with a point about language. We've heard several of our colleagues refer to the tens of thousands of deaths and woundings by firearms in America every year as tragedies. You know, Romeo and Juliet is a tragedy. Macbeth is a tragedy. Okay, these are crimes, and many of them are avoidable crimes. And to describe them as a tragedy is a way to suggest that somehow it's just out of our control, it's unavoidable, it's inescapable. So I think that we need to start taking responsibility for what's actually taking place in our country with respect to gun policy. 109 people are dying every single day because of firearms, are killed by firearms. More than 230 people every day are shot and wounded. The US gun homicide rate is more than 25 times higher than that of other higher income countries. Now, why would that be? Every study has shown that it is the radical permissiveness and laxness of our gun laws that has given us a rate of gun violence and gun homicide so much higher than the rest of the industrialized world. Firearms are the leading cause of death for American children and teens, more than automobile accidents, cancer, and other causes. Women in the United States are 21 times more likely to be killed than women in other high income countries by intimate partner violence by a firearm. There are nearly 1 million women alive today in America who've been shot or shot at by their intimate partners. So we are an extreme outlier when you look at the entire world. And all we get is a recipe for despair and inaction by our colleagues. We know that the Brady background checks have worked to stop millions of gun purchases by people who are not qualified to get them. The Brady law says if you're a felon, if you're a fugitive, if you are a drug addict, if you are otherwise someone who would be dangerous to get a gun, you can't get it. And the problem is that there are these gaping loopholes out there: the private gun show loophole, the internet loophole, the private sale loophole, that allow people to circumvent that process, which has worked to stop lots of unqualified people from getting guns. So we're trying to close the loopholes. And what do we get from the American people? The vast majority of people support it. More than 90% of the American people. You can't get more than 90% of the people to support anything, and the vast majority of the American people support doing it, but not our colleagues across the aisle who now play a very familiar game. Anytime we're trying to close the loopholes, and create a system that works, the kind of system that works in countries all over the world, in France, in Japan, in UK, in China, in Israel, you name it. These systems work all over the world. When we try to do it, they say, well, it would not have stopped this particular crime at the Tree of Life Cinema. It would not have stopped that crime in El Paso. It would not have stopped that crime in Sandy Hook, or the dozens and dozens of crimes that take place every day. And if it would have, they said, well, this person's a criminal and they don't follow the law. Therefore, we can't change the law because you're not going to stop a criminal anyway. In other words, it's always a recipe for paralysis and inaction and not doing anything. It is a do nothing approach. Just surrender to gun violence. And we hear it every single time. Now, I believe that Mr. Rushenthaler got to the heart of the matter. And I think it was inadvertent, but he kept saying, do you know that less than 1% of the guns that are used in criminal violence actually came from licensed gun dealers? That's the whole point. That's the entire point. You've got these gaping loopholes in the system with the private gun show sales, with the internet sales, with the parking lot of 7-Eleven private sale, and those guns go into the black market and the gray market and the illegal criminal markets, and people can access those guns. And America is an absolute outlier in allowing that to happen. And we know exactly what needs to be done to crack down on this criminal gun traffic, but some people are too much in the thrall of the NRA to do it. But the vast majority of the American people want it today. Let's pass H.R. 8. Let's close the Charleston loophole. To say, well, criminals are going to go ahead and violate the law anyway. Well, why have a law against murder? Murderers are going to violate the law anyway. Why have a law against rape? Rapists are going to violate the law anyway. We have laws to define standards to use the force of the state to try to stop people from violating the law. So we don't get this proliferation of guns throughout society. So anybody can find a gun to go out and commit a crime. So I just want to come back to Chairman Nadler for a second. The whole thing, I understood, some of our colleagues are now hanging their hat on, they want to be able to transfer a gun for the afternoon to their brother or their sister to go hunting. Isn't there already an exception for that in the law, that you can transfer a firearm to a family member?
Yes, you're quite right. There is such an exception, and these two bills would not change that at all.
Okay, so in other words, if you want to transfer it to a close family relative, you can do that.
Yes.
And the real problem is how many people are dying because of the easy availability of guns and kids picking up guns and shooting a sibling, ruining everybody's life in the family. I mean, come on. Well, why can't we deal with this as a serious public health problem? Why does it always have to be infected by so much propaganda and ideology? I yield back to you, Mr. Chair.
Thank you very much, Ms. Scanlon.
Thank you, Chairman McGovern. This issue is huge in my district. For too many communities in southeastern Pennsylvania, gun violence is a horrifying daily reality. While mass shootings get national headlines, in my district, the steady toll of gun violence day after day delivers the equivalent of a mass shooting every week or two. So we often talk about the ways in which COVID-19 has changed our day-to-day life in America, and it has in many ways. But when it comes to gun violence, we've had an uptick of gun violence throughout the country, and it's playing out in the background of this pandemic. In my region, we're at the epicenter. In Philadelphia, more than 20 children were killed by firearms in 2020, nearly double the number from the previous year. And in less than 3 full months this year, almost 300 people in Philadelphia have been shot. Over 50 have been killed. The homicide rate has skyrocketed, and according to our police commissioner, officers are on pace to recover more than 6,000 guns used in crimes. Now, this isn't a Second Amendment issue. This is a public health crisis. And at this point, Everyone in this hearing is familiar with the response that a public health crisis demands. To address gun violence in America, we need a comprehensive and multifaceted approach. There is no one size fits all, but it has to be driven by research and data. The measures we're talking about here today are a great common sense start to keep firearms out of the hands of criminals and gun traffickers, keep weapons of war off the street, and keep illegal guns out of my community. We must recognize that the bills we're talking about here today are important tools to aid law enforcement. You know, the Supreme Court, even our Republican colleagues here, agree there are limits to the Second Amendment. To quote Justice Scalia, nothing should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding the carrying of firearms in sensitive places. That's 2008, DC versus Heller. The bills we're considering here close major loopholes that allow people who we all agree should not be allowed to purchase guns without a background check. Over 3 million people have been who are legally prohibited from possessing a gun have been stopped using background checks. Now, my colleague from Pennsylvania was asking about potential mass shootings that could have been stopped with a background check. Well, in 2019, the guy who fatally shot 7 people and wounded 25 others in West Texas had failed a background check when he tried to purchase a gun. But loopholes in our gun laws allowed him to bypass the background check and obtain the AR-style weapon that he used from an unlicensed seller who wasn't required to run a background check. So if you want a mass shooting that could have been prohibited or prevented by these laws, look at West Texas. Individuals who commit crimes with firearms often seek out sellers who aren't required to run those checks. Purchasers from armslist.com, which is a major online firearms marketplace, those purchasers are almost 7 times as likely to have a firearm prohibiting criminal record than people who buy from licensed dealers because they know they're not going to have to go through the same kind of rigor. Finally, as we've heard from several of our colleagues, responsible gun ownership for hunting and sport has a long history in this country. It was even one of the original purposes of the NRA before it was taken over by the radical right and commercial interests. I grew up in a family, upstate New York, along with Mr. Morelli, where hunting and skeet shooting were regular weekend activities, but that's not what we're talking about here. We're talking about closing gaping loopholes in our laws that allow responsible buyers and sellers to, irresponsible buyers and sellers to purchase weapons when we all agree they shouldn't have them. And I give responsible gun owners a lot more credit and believe they'll be able to follow the law without having their Second Amendment rights impacted. So I do want to ask Chairman Nadler, you know, in southeastern Pennsylvania, we're impacted by what some call the iron pipeline. Guns from states with weak gun laws flow up north via the I-95 corridor, and they end up in states like mine. We see guns from southern states trafficked in Pennsylvania, and in recent years, we've seen more guns trafficked into the Philadelphia region via gun shows in other parts of the state. These are the guns wreaking havoc on our city streets and throughout my district. Can you speak to how closing the background check loophole helps to halt the travel of guns along the iron pipeline into, throughout, and out of our state?
Well, it would go a long way to, it couldn't totally stop the iron pipeline. As I've said before, no system can totally stop all misuse of guns, but it could greatly limit it, because now we would have a situation where the FBI has time to check the bona fides or the criminal records, the wife beating status, all the situations that should preclude someone from getting a gun because it tells us it's dangerous. Under the current law, the FBI has 3 days. Under this law, it would have more time, and it would be able to do what it has to do. That's one thing that would happen. The other thing is a total absolution from the current laws, as I've said before in this meeting, from unlicensed gun dealers. An unlicensed gun dealer can give away guns or sell guns to anybody, regardless of the background checks. He's not subject to it. So this would subject an unlicensed gun dealer. And unlicensed doesn't mean he's giving away guns for free. It simply means he is not licensed as a dealer. He could be selling the guns. He could be giving them away, although I doubt he's giving them away, but he could be selling them. But he's not subject to the background checks. So closing those two loopholes, which is what these two bills do, essentially would greatly reduce the number of guns in the hands of people that I think universally would agree shouldn't have guns, and this would greatly cut down the shootings. Now, as Mr. Raskin mentioned before, no other major country has the kind of gun deaths that we do. 25-to-1 ratio. Now, some of the defenders have said that, well, people in the United States are less rational. I refuse to believe that people in the United States are 25 times as crazy as people in France, or that 25 times as many people proportionally in the population are crazy in the United States as people in France or Great Britain or Japan or Germany. So we have seen the efficacy of this kind of law in many, many other countries, in fact, in almost all countries, except the United States.
Thank you. Just the three provisions that we've talked about here today, requiring background checks for online gun sales where there's disproportionately more people obtaining guns who shouldn't, background checks for gun shows, and universal background checks so other states can't undermine our efforts to protect folks in my state. Those three things alone are going to dramatically reduce the influx of guns and guns that are provided to people who shouldn't have them. So thank you. And with that, I yield back.
Thank you very much. Mr. Morelli.
Thank you, Mr. Chairman, for holding the hearing on this subject. I want to thank the Dean of the New York delegation, the distinguished Chair of the Committee on the Judiciary, for his long involvement in this work, going back to when Mr. Nadler and I served together in the New York State Assembly. He's long been an advocate for this. For me, the essential nature of guns and firearms are as weapons. They were invented in the 14th century as part of military efforts and eventually evolved to what we have today. I'm sure the founders would not even recognize modern firearms. And so it seems to me in any society with, thoughtful people, they would want to make sure, even in ours where we have a guarantee under the Second Amendment as a right to that firearm, although there's some question about whether the founders actually intended for well-regulated militias or individuals. But notwithstanding that, let's accept the premise that individuals have that right, and that's in the Bill of Rights. The question then is, what does a reasonable society do? What measure do they take to prevent a killing instrument to make sure it doesn't end up in the wrong hands? And I think, to people who are focused on mass shootings, and obviously they're tragic, they're horrific, they're heartbreaking, but 19,000 gun deaths were recorded in the year 2020 just in America, a 25% increase over the previous year. Almost 20,000 people losing their lives. And the argument here, I guess it's probably good that when the founders wrote the Constitution, we hadn't invented the automobile, because people might be arguing against registration of automobiles, driver's licenses, requirements for insurance. And by the way, despite the fact that we do all that, people still die in automobile accidents. So you can't prevent accidents from happening. When people say, well, this would have happened or that would have happened, notwithstanding efforts to try to make sure that we live in a safer society, that's obvious. Things do happen. And also, I think, as Mr. Raskin pointed out, Ms. Scanlon and others, that it's a little bit of a circular argument if you say, well, only lawbreakers no one will abide by the law. Yeah, I guess that's true. In that case, I'm not sure there's any point to us being here ever then. I mean, if you take the view that all criminal law will be broken, therefore it shouldn't be put in place in the beginning, it seems to me a nonsensical argument. We want to do what's in the best interest of all Americans to continue to protect that Second Amendment right. But in my mind, at least, there is no exclusivity. It's not mutually exclusive, whether we have laws that protect the public to make sure that people abide by certain regulations, that background checks exist. I actually support universal registration of a deadly weapon. I think it makes entire sense, and I don't think that's violative of the Second Amendment either. And I would say, and I might encourage my colleague from New York, I have legislation, the Gun Theft Prevention Act, which would require standards for gun shop owners and people who engage in the sale of guns and all types of firearms. I think it's something we ought to investigate at the federal level to make sure that what Ms. Scanlon talked about, the iron pipeline, where people are now selling into places like New York, which have stronger gun laws, to begin to stop that from happening by having universal standards for all gun shop owners in the country. And I would recommend that. But at the end of the day, I, again, think that what we seek here is balance. What we seek here is a way to ensure Second Amendment rights are protected, but that ghastly number of 19,000 people who lose their lives to gun violence every year must be there must be a national imperative to stop that and to do that while respecting Second Amendment rights. I think these are modest steps. I think they're common sense. And and the point raised by a number of my colleagues, it's broadly supported by the American people, who I think have more common sense perhaps than some of the people elected to represent them think they have. And with that, I'll support the rule and the underlying bill, and I yield back, Mr. Chair.
Thank you very much. Mr. DeSaulnier.
Thank you, Mr. Chairman. I just want to associate myself particularly with Ms. Scanlon's comments that if you approach this as a public health, evidence-based research challenge, you statistically get positive changes. So in states like California and Connecticut, where we have reasonable violence prevention laws, you're statistically less likely to suffer from gun violence, whether it's a homicide, suicide, or an injury. And then as far as guns used in crime, 80% of guns used in criminal activity are purchased from an unlicensed seller. And 96% of people who are convicted in prison who have used a gun in a crime got them from an unlicensed provider. And for a state like California, about a third of the guns used in crime in California are imported illegally from other states. So from a statistical standpoint, these laws work, and this law will work in the United States and will provide a greater safety, and the billions of dollars in public cost for gun violence will start to be lessened. Thank you, Mr. Chairman.
Thank you very much. Ms. Ross.
Thank you, Mr. Chairman. Most of the points that I would make have been made, but I do want to share a couple things with the committee. It is just a fact that universal background checks can save lives, and that the bills that we're discussing today are simply common sense gun safety legislation. And I want to share something. You know, we got to go home this past weekend for a couple of days before coming back early for this meeting. And I, of course, did a bunch of things about COVID relief and attended precinct meetings. The only issue where I got unsolicited constituent requests over the weekend, going out and doing errands, getting Facebook messages, was on these background check bills. People know that we have an opportunity to vote on them. They are so concerned about the wrong people getting guns and hurting themselves, hurting others, that people came up to me in a shopping center and told me, and as a matter of fact, the guy who came up to me said, I used to be a Republican, but not anymore. We need these background check bills. Suburban folks in Apex with Moms Demand Action contacted me. The people of this country know that this is common sense gun safety. They know it has been held up for partisan reasons, and they want us to get about the business of protecting them. And with that, Mr. Chairman, I yield back.
Thank you very much. Does any other member wish to ask a question? Hearing none, I would like to thank our witnesses for their testimony. You are now excused. Does any other member wish to testify on HR 8 or HR 1446? Hearing none, that closes the hearing on HR 8 and HR 1446. I want to welcome our next panel to testify on their amendments to HR 842. Mr. Good, Mr. Grothman, Ms. Miller Meeks, Ms. Stefanik, Mr. Wilson, and Mr. Owens. And we'll begin with Mr. Good.
Thank you, Mr. Chairman.
Okay.
Great to be with you all today. And I have two amendments to present. The first one, HR 842 allows the National Labor Relations Board to levy financial penalties against businesses, corporate officers, and directors who can be held individually liable for unfair labor practices. This amendment applies HR's 842 private right of action, expanded liabilities, and new penalties to unfair labor practices by unions in the same way they apply to employers. Again, HR 842 radically expands liabilities and imposes penalties for unfair labor practices committed by employers under NLRA. And this amendment simply levels the playing field so that unfair labor practices by unions are treated the same under the NLRA as unfair labor practices by employers. Current law under the NLRA applies to both union and employers' unfair labor practices, but HR 842 only expands that liability, increases penalties for unlawful employer actions. Yet another example of how this bill is more about the power of union bosses than the power of about the rights of workers. Republicans believe in equal application of the law. Unfortunately, Democrats only seem to believe in penalizing employers and letting the union bosses off the hook. By imposing one-sided liabilities and penalties for unfair labor practices, Democrats are tacitly admitting they don't think unions should be held to the same standards as employers. So if Democrats want to alter the NLRA to punish unfair labor practices, equal penalties should apply regardless of who is violating the law. So I urge my colleagues to adopt this amendment and level the playing field between employers and union in unfair labor practices. Failing to adopt it is inequitable and exposes Democrats' singular interests in only promoting the interests of organized labor. My second amendment, no pun intended with the previous discussion. My second amendment would amend the Labor Management Reporting and Disclosure Act to provide greater fairness and transparency for job creators and the American worker by prohibiting so-called neutrality agreements. Neutrality agreements are entered into by employers and labor organizers, promising the employer will remain neutral in labor organizing efforts. But sadly, those agreements are often anything but neutral in theory or in practice. Neutrality agreements guarantee that workers will only hear one side of the story in labor organizing efforts, only the side presenting the union boss's interests. This restriction presupposes that employers, the people who are providing a worker's job, wages, and benefits, and seeking to attract and retain the best workers, that employer cannot fairly or transparently weigh in on matters related to unionizing. In short, neutrality agreements are grounded in the same anti-business presuppositions as other leftist labor policy that assumes businesses are nefarious actors working against their employees. Furthermore, neutrality agreements are essentially things of value that should be prohibited and not exchanged between companies and unions. Businesses that do not agree to neutrality agreements are often subject to long-term and sustained harassment from labor organizers, which destroys their reputations and their livelihood, not to mention ultimately the livelihood of their workers. Far too often, when employers agree to neutrality agreements, they do not serve as neutral arrangements, but instead they provide support to labor organizers, such as when private employee information is collected and distributed to unions to make their political efforts easier. With neutrality agreements, employers often must choose between being tarred and feathered by labor organizations or colluding with them at the ultimate expense of their employees and the viability of their businesses. So I urge my colleagues to adopt this amendment as well. Thank you, sir.
Thank you very much. Mr. Grothman. Yep, you have to unmute.
There we are. Okay, yeah, I have a amendment dealing with the union authorization cards. We're clarifying that at the time these cards go out, they should be accompanied by additional information, which we feel would be only fair. First of all, we feel the card should specify that the cards will be used to certify a labor organization as the exclusive bargaining agent of the employees, so they understand the significance of the card. And secondly, we want to make sure the card clarifies the rights of the employee and the total monthly dues and fees charged by the labor organization. So we feel that'd be fair to put that with these authorization cards to give people a little bit more of the idea of what they're signing. My only amendment. I'm making it easy on you guys.
Okay, thank you very much. Ms. Miller Meeks. Yeah, so Dr. Miller Meeks, we need to, your camera's not on and we need you to unmute. Okay, so why don't we can come back to Dr. Miller Meeks. Let's go to, is Ms. Stefanik?
Yes, I'm on,
Yeah.
Mr. Chairman.
Okay, why don't you proceed?
Thank you, Mr. Chairman and members of the Rules Committee for the opportunity to testify today on my amendment to HR 842, the PRO Act, which I'm offering on behalf of myself as well as my colleagues, Representatives Steele, Good, and Harshbarger. This amendment is very simple. It would strike the radical ABC test for worker classification from the bill and defend the freedom to engage in the modern economy with independence and autonomy. The PROS Act ABC test is modeled after the California Supreme Court's Dynamics decision and the wildly unpopular AB5. This would be disastrous for the millions of Americans who choose the opportunity to freely engage in the economy as independent contractors. The California law has been destroying the livelihoods of freelancers and individual entrepreneurs across the state, even with its lengthy list of over 100 carve-outs and exemptions. When the House last voted on the PRO Act, AB5 had just come into effect in California, but now we know, and we have countless examples of the tragic real-world impact of the ABC test on hardworking families. This has impacted seasoned marketing professionals who have been pushed out of the workforce in the height of their careers. It's impacted independent musicians who have been stripped of the ability to find gigs. It's impacted ASL interpreters who are unable to continue serving students and families in need of support. And as harmful as California's law has been, the PRO Act brings this ABC test nationwide. This effort to largely eliminate contract-based work fundamentally misunderstands those who choose to work independently. Survey data shows that the vast majority of independent workers prefer their status as independent contractors, and of those who quit their full-time job to freelance, 3/4 say they earn as much or more than when they work for a traditional employee. But monetary benefit is not the only reason Americans choose independent work. 74% of working women say that they choose to work independently for the flexibility it provides themselves and their families. This freedom of independent work serves as a catalyst for small business formation in communities across the country, while part-time gigs continue to provide an important source of supplemental income for workers seeking economic security, especially during the pandemic. Now, I know my colleagues on the other side of the aisle say this provision, as problematic as it has been for California, is necessary to prevent employers from misclassifying their workers as independent contractors. But the ABC test is not about addressing misclassification. It is about reclassifying millions of independent workers to fit in the constructs of traditional employment, robbing them the flexibility and entrepreneurship opportunities they value and they choose. If we truly want to empower workers, we should focus on updating federal law to end the patchwork of regulations and provide one clear federal standard for worker classification, delivering certainty for businesses and a level playing field for independent contractors. I have legislation to do just this, the Modern Workers Empowerment Act. Ultimately, this is about freedom, the freedom to engage in the economy as independent contractors. It's about empowerment, about fostering the entrepreneurial spirit our nation was built upon. The PRO-ACT ABC test would impose a one-size-fits-all mandate that takes this choice away from millions of Americans. It's a bad deal for workers, it's a bad deal for families, and it's a bad deal for the future of innovation and opportunity in this country. So I urge my colleagues to support this amendment and the millions and millions of workers whose livelihood depends on making sure that we protect their right and their choice to be independent contractors. And I yield back.
Thank you very much. Mr. Wilson.
Thank you, Mr. Chairman. And Mr. Chairman and colleagues, this amendment that I have, 59, amends Section 111 of the PRO Act and inserts HR 1275, which provides for laws already in place in 27 states, which eliminates the automatic dues clause in federal statutes without adding a single letter to federal laws. This promotes worker freedom and it was inspired indeed by our ranking member Virginia Fox. Not having the government mandate paying union dues, which may contradict a worker's political preferences. In 27 states, they already have adopted this bar to force union dues paying, leading to greater economic vitality, creating jobs, and it will foster growth and lower unemployment. In South Carolina, we've seen the success of such a law without forced dues. I've seen firsthand the job creation if we have expanded and protected the freedom of American workers. We've attracted Michelin, Bridgestone, Continental Tire, and GT to South Carolina, and now South Carolina is America's largest tire producer and exporter. With BMW, Volvo, Mercedes, Sprinter vans, South Carolina is America's largest manufacturer and exporter of cars. I'm grateful to have 15 co-sponsors of this particular amendment, indicating the importance of the amendment, and I urge that it be included in the final consideration of vote on the floor, and I yield back my time.
Thank you very much. Mr. Owens.
One second. Thank you, Mr. Chairman and my colleagues. I want to offer the freedom to negotiate amendment. This amendment ensures that labor unions and businesses can negotiate satisfactory working conditions without government intervening, stopping negotiations prematurely. The PRO Act imposes mandatory binding arbitration to settle contract disputes under the guise of knowing what's best for both sides. If the union employer cannot agree, the bill requires government bureaucrats to select an arbitration panel comprised of 3 members. These arbitrators would then be required to impose a 2-year contract without a vote of approval from workers or the employer. Arbitration is promoted as a good faith process to resolve disputes, overseen by a fair and impartial fair and impartial process. However, HR 842 would lead to more conflict by requiring an unelected third party to impose a binding private contract. Arbitration is intended to result in an agreement that works for all sides, but this bill creates a biased shortcut that severely limits employer rights. I urge my colleagues to support this amendment that minimizes the economic strife and labor unrest created by HR 842. Thank you, and I yield back.
Thank you very much. We're now going to add Mr. Cawthon to the panel and yield to him. And then when he's finished, we'll try to go back to Dr. Miller Meeks. So Mr. Cawthon.
All right. Thank you, Chairman McGovern and Ranking Member Cole for the opportunity to testify today. The freedom to work is integral to the American spirit. No one ought to face retaliation or discrimination in the workplace. Make no mistake, in the current system, those who choose to break from the union drumbeat face instant and severe retaliation. This amendment would place the power of choice back into the hands of the people and empower workers with the ability to earn a living without fear of punishment. No one ought to be punished for deciding to work. No one ought to be punished for exercising personal freedom and individual dignity. This amendment protects the individual freedom of the worker by ultimately protecting union members from being punished by a union for continuing to work during an ongoing labor dispute. Currently, union members can legally be fined, punished, or face other retaliation from their union for refusing to participate in a strike and choosing to work instead. This amendment simply allows union members the same right as non-members, the right to earn a living free from union punishment. A vote on this amendment will reveal much about who we are elected to serve. Are we, as representatives of the people, elected to serve union management, or are we elected to serve the people themselves? I ask each of us to consider who we truly serve. And with that, I yield back.
Thank you very much. And now we're going to try Dr. Miller Meeks again.
Am I there?
You are here.
Thank you, Chairman McGovern. My amendment, Miller Meeks Amendment, is an amendment that tries to clarify a confusing and unworkable provision which directs the National Labor Relations Board to consider indirect or reserved control of the essential terms and conditions of employment when determining whether a company is a joint employer. This amendment ensures corporate social responsibility initiatives, including those that impose requirements on a third-party business relationship, such as supply chains, are not evidence of a joint employer relationship. This amendment protects important and effective corporate social responsibility initiatives from being used as evidence of joint employment, allowing employers to exert their influence to improve working conditions, environmental conditions, and community engagement throughout their supply chain without risking the liability of joint employment. Many companies implement significant positive business practices benefiting the economy, workers, the environment, and their communities through corporate social responsibility activities. These initiatives are often most effective when they go beyond the companies themselves and apply to business partners, vendors, and others in the supply chain. These initiatives allow companies with resources and expertise to connect and assist small businesses and other focal points of communities. Within the last year, we've seen that corporate sustainability programs can be valuable contributors to public health programs, ensuring COVID-19 testing occurs in under-tested communities, providing access to life-saving vaccinations, including the flu shot, and distributing desperately needed resources to nonprofits. These voluntary initiatives are an excellent way to improve our society without the heavy hand of government mandates. Unfortunately, under HR 842's broad, vague joint employer standard, these well-intentioned initiatives could mean thousands of additional workers are deemed to be the primary company's employees, subjecting the primary company to union harassment, lawsuits, and more. No one in Congress wants to inhibit the ability of businesses to serve their customers and communities in time of need, but that is exactly what HR 842 would do. Many companies would be forced to curb these well-intentioned ventures to avoid the risk of liability resulting from the joint employment standard mandated by HR 842. This at a time when countless individuals are struggling during a pandemic and in need of support from every possible source. I urge my colleagues to work together across the aisle to protect critically minded service programs that are helping our communities by supporting this amendment. Thank you, Mr. Chair. I yield back my time.
Thank you very much. And I'm told we have one additional person, Ms. Miller of Illinois. We'll ask that you be on this panel and you may testify. You need to unmute though.
How's that? Thank you, Mr. Chairman. I want to testify on an amendment I'm proposing to HR 842. This amendment allows all workers in a bargaining unit to vote by secret ballot on workplace decisions with far-reaching impacts on their livelihoods and families. Union leaders negotiate collective bargaining agreements on behalf of a broad group of workers, but that does not mean that the deal works best for each individual worker. Multi-employer pension plans are facing a major insolvency crisis. While union bosses might sell these plans to workers as a great long-term deal, all workers should be able to vote by secret ballot, free of external pressure, on whether to join a multi-employer pension plan. In addition, strikes can impose significant disruption and financial hardship on workers, since union strike funds often compensate union members far less than their normal wage. Moreover, Non-union members are ineligible to draw from strike funds. This potential loss of pay warrants input from all workers through secret ballot. According to polling from the Opinion Research Corporation, 85% of union households support secret ballot votes to approve strikes. Workers should not be pressured, coerced, or misled into accepting a collective bargaining agreement, pension, or strike, and all workers should have a vote when these issues are decided. Each of these decisions directly impacts the ability of workers to put food on the table and provide for their families. Allowing union boss pressure to influence these decisions and excluding workers from voting on them is wrong. Union bosses may oppose this amendment because it makes them more accountable to the workers they claim to represent. But this common sense reform will expand the rights of workers while protecting their ability to bargain collectively for benefits and engage in strikes. I urge all my colleagues to accept this amendment. Thank you.
Thank you. I yield to Ms. Hinson.
Thank you, Mr. Chair, and thank you to the members being on today. I appreciate the opportunity to come on and testify to the members of the committee. I come by today to testify in support of two common sense amendments that I've offered to the PRO Act. The first of these amendments is simple and it's bipartisan in origin. Actually, Democrats wrote it originally. This amendment is Hinson number 15, and it would reinsert the whistleblower protections provisions that were included in this bill during the last Congress. I'm not sure why they were removed, and I believe regardless of the administration and power, we can all agree whistleblowers should be protected here. I stand strongly in support of transparency in good government, and I'm confident that everyone on this committee shares that fundamental belief with me. So my amendment would prevent discrimination against anyone who reports violations of this bill once it's enacted. We could all agree that nobody should be fired for telling Congress when a law is being broken. And as such, I ask that you make this amendment in order and join me today in protecting whistleblowers. And then my second amendment, Hinson number 60, is another effort that I believe could also gain bipartisan support here today. COVID-19 relief is desperately needed across our country, and my amendment today aims to support this effort in a practical way. It would exempt workers from having to pay union dues or fees if they can demonstrate financial hardships due to COVID-19 and the pandemic. This pandemic-related COVID-19 hardship would be proven simply if an individual received any kind of COVID relief under the CARES Act or the December coronavirus response package. He or she could not be forced to pay a union. This is common sense in providing this relief. Iowans and all Americans need every extra dollar right now as our economy recovers. If an Iowa family is struggling right now under this pandemic, it would be outrageous to expect that a family would be able to spend its limited resources on union dues or fees, when instead that could be going to put food on the table. So I would ask you join me in helping to provide relief for Iowa families and American families and exempting them from having the added burden of union costs during this pandemic and with that relief. So with that, Mr. Chairman, thank you so much for the opportunity to testify, and I yield back.
Thank you very much. And let me say, without objection, I'd like to insert statements from Representative Garcia and Jackson Lee into the record. Are there any questions for this panel? On the Republican side, Mr. Cole?
Mr. Cole, or excuse me, Mr. Chairman, I have no questions, but following your lead, I have two statements I'd like to introduce. One is by our colleague, Mr. Hill, related to HR 842, and the other is by our colleague, Mr. Bost of Illinois, related to HR 8 and HR 1446. And then we also have a third, I'm sorry, by Mr. Rice. As well. So I'd ask unanimous consent to insert those statements.
Without objection.
Thank you, Chairman.
Any questions on the Democratic side? Let me go back to the Republican side. Any questions? Hearing none, then I thank the panel and you are dismissed. Is there anybody else who wishes to testify on HR 842? Seeing none, this closes the hearing on HR 842. All right. At this time, the chair will entertain a motion from the distinguished gentleman from Pennsylvania, Ms. Scanlon.
Thank you, Mr. Chairman. I
You got on mute?
Unmute, yeah.
Sorry, I was anticipating. Mr. Chairman, I move the committee grant HR 842, the Protecting the Right to Organize Act of 2021, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment printed in Part A of the Rules Committee, Rules Committee report shall be considered as adopted and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides that following debate, each further amendment printed in Part B of the Rules Committee report not earlier considered as part of amendments en bloc pursuant to Section 3 shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, the chair of the Committee on Education and Labor or his designee may offer amendments en bloc consisting of further amendments printed in Part B of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor or their designees, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides one motion to recommit. The rule further provides for consideration of HR 8, the Bipartisan Background Checks Act of 2021, under a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides that following debate, each further amendment printed in Part C of the Rules Committee report not earlier considered as part of amendments en bloc pursuant to Section 6 shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, the chair of the Committee on the Judiciary or his designee may offer amendments en bloc consisting of further amendments printed in Part C of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides one motion to recommit. The rule further provides for consideration of HR 1446, the Enhanced Background Checks Act of 2021, under a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the bill should be considered as read. The rule waives all points of order against provisions in the bill. The rule provides that following debate, each further amendment printed in Part D of the Rules Committee report, not earlier considered as part of amendments en bloc pursuant to Section 9, shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, the chair of the Committee on the Judiciary or his designee may offer amendments en bloc consisting of further amendments printed in Part D of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides one motion to recommit. The rule waives all points of order against amendments printed in Parts B, C, and D of the Rules Committee report or amendments en bloc described in Sections 3, 6, and 9 of the resolution. Section 11 of the rule provides that on any legislative day during the period from March 13, 2021 through April 22nd, 2021, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time within the limits of Clause 4, Section 5, Article 1 of the Constitution, to be announced by the chair in declaring the adjournment. The rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 11 as though under Clause 8A of Rule 1. The rule provides that each day during the period addressed by Section 11 shall not constitute a calendar day for purposes of Section 7 of the War Powers Resolution, a legislative day for purposes of Clause 7 of Rule 13, or a calendar or legislative day for purposes of Clause 7C1 of Rule 22. The rule provides that it shall be in order at any time through the calendar day of April 22nd, 2021, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15. The Speaker or her designee shall consult with the minority leader or his designee on the designation of any matter for consideration pursuant to this section. The rule provides that the requirement of Clause 6A of Rule 13 for a 2/3 vote to consider a report from the Committee on Rules on the same day it is presented to the House is waived with respect to any resolution reported through the legislative day of April 22nd, 2021. Finally, the rule amends Section 4D of House Resolution 8 by adding at the end of the following, quote, 5, the Select Committee shall be composed of 16 members, delegates, or the resident commissioner appointed by the Speaker, of whom 7 shall be appointed on the recommendation of the minority leader, end quote. End of rule. I yield back.
Thank you very much. You want to repeat it one more time? No, just kidding.
Sure.
Yeah,
10 hours.
before you've heard the motion from the gentlewoman from Pennsylvania. Before I go to any amendment or discussion, I just want to add one thing. A few weeks ago, Ranking Member Cole raised concern with the fact that the consensus calendar was not yet live this Congress, and I want to thank you for raising these concerns with me, and would like to note that this rule removes the pause on the consensus calendar, meaning the consensus calendar will be active again starting on March 13th. The consensus calendar is a helpful tool. We worked with the problem solvers on to help develop to expedite legislation with broad bipartisan support. So thank you to both Ranking Member Cole and the bipartisan problem solvers for bringing this to our attention. In the interest of bipartisanship, I'd like to point out that this rule also adds a Republican slot to the Select Committee on the Climate Crisis. So having said that, are there any amendments or discussion? Mr. Cole.
Thank you, Mr. Chairman. Two things before I move to my amendments. First, thank you very much. We appreciate your response on the consensus calendar. I think we had some other things. We hope to, as you consider them, you'll be able to favorably look at those as well.
We don't want to do everything all at once. We want to.
I certainly understand that. I'm trying to encourage this good behavior, Mr. Chairman, and express my deep appreciation. And I just want to express my admiration for the gentlelady from Pennsylvania to get through that whole thing without a mistake. I couldn't read that well if I tried. I mean, it was just it was an impressive performance by my friend. With that, Mr. Chairman, if I may, I'd like to move that we provide an open rule for HR 8, HR 842, and HR 1446. We all know, look, this is the beginning of the session, and these bills got some hearings in the last Congress, but we do have 60 new members here. There are changes in these bills in many cases, and we think members, particularly that weren't here in the last Congress, and frankly, members that have concerns about some of the changes made in this Congress ought to have the opportunity to present their ideas and their amendments on the floor. It's not as if we don't have time, in my view, to do this. So I would hope you would consider that and give us an opportunity to flesh these bills out. And I would also remind the majority, and I do this with real respect, their majority is a lot smaller than it was last time. And that too would suggest that just relying on the opinion from the last Congress might suggest or might have some challenges with it. So with that, again, I would move for an open rule, Mr. Chairman.
You heard the amendment from the gentleman. Is there any discussion? Hearing none, the vote is on the simple amendment. All those in favor say aye.
Aye.
Opposed, no.
No.
Opinion of the chair, the noes have it.
Mr. Chairman, on that, I would ask for the recorded vote.
Clerk, a recorded vote has been asked for. The clerk will please call the roll.
Mr. Hastings, Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
No.
Mr. Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin, no. Miss Scanlon,
No.
Miss Scanlon, no. Mr. Morelli,
Morelli is no.
Mr. Morelli, no. Mr. DeSaulnier,
No.
Mr. DeSaulnier, no. Miss Ross,
No.
Miss Ross, no. Mr. Cole,
Aye.
Mr. Cole, aye. Mr. Burgess, Mr. Reschenthaler,
Aye.
Mr. Reschenthaler, aye. Mrs. Fishbach,
Aye.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk, report the total.
3 yeas, 8 nays.
The amendment is not agreed to. Are there further amendments?
Mr. Chairman, I have an additional amendment.
Mr. Cole.
Thank you very much. I would ask that we make an order amendment number 47 to HR 842. That's by Mr. Allen. And basically, this simply strikes section 111 of the bill, which overturns state right to work laws. I think it's an extraordinary thing for us to decide as a Congress that we're going to overturn the individual legislation in 27 separate states. I'd say for the record, Mr. Chairman, in my own state of Oklahoma, that was not a legislative act. That was a vote of the people. That was a question that was a constitutional amendment and was fought out each side. So we would be expressly in the state of Oklahoma overturning the express, will of the electorate. And that's just simply, I think, an extraordinary overreach by this body. So I think what you want about a lot of the other things ago, we should not be, overturning state laws at the federal level that are, whether you agree with them or not, are certainly perfectly constitutional in 27 separate states. So I would urge Mr. Allen's amendment be made in order, Mr. Chairman.
Heard the gentleman's amendment. Any discussion?
Yeah, I'd like to, Mr. Chair, just,
Perlmutter.
all those state laws come from the Taft-Hartley Act, which is a federal law. So I would disagree with the logic of my colleague from Oklahoma as to these individual votes by the states, but they come from the Taft-Hartley Act, which in my opinion was bad law when it was passed a long time ago, and I yield back.
Well, with all due respect to my friend, I think that's an irrelevant point. I mean, the reality is people chose, whether we had Taft-Hartley or not, they could have, theoretically had a right to work law in their own state. And again, the idea that somebody in Colorado, with all due respect to my friends, is going to decide what people in Oklahoma do makes about as much sense as for us prescribing what your state law should be. And I would never presume to do that. I think it's a mistake.
Can I say the gentleman from Oklahoma, he said Allen number 47. Was that the right?
Well, that's, I said it's amendment 47 to HR 842. That's what I've got, but we'll double check, Mr. Chairman.
Yeah, well, that one is in order.
No, well, good. We had not yet been seen the rule.
That's the right one.
We usually wait to the end, but so that one may be in order. Hang on, we're checking if that's all right, Mr. Chairman, and I'll withdraw. It is? I'll withdraw the amendment, and thank you very much, Mr. Chairman. I appreciate that.
All right, further amendments.
Maybe I should move to strike it.
No, please.
Your opposition always helps, Mr. Perlmutter.
Further amendments. There are further amendments? Okay.
Shut it down before they put more into it.
Mr. Chairman, excuse me for the confusion.
Mr. Reschenthaler has an amendment.
Thanks, Mr. Chairman. Mr. Chairman, I have an amendment to the rule to make an order amendment 34 to HR 8, which is offered by my good friend and colleague, Mr. Stubbe from Florida. This amendment adds a new exemption to the background check requirement, allowing the transfer of firearms to the spouse of a deployed member of the armed forces of the United States. Mr. Chairman, this amendment will provide peace of mind for deployed service members concerned about the safety of their loved ones back home. Mr. Chairman, when I deployed to Iraq, I didn't even leave behind a house plant to worry about, but for many men and women who do deploy, they leave behind a spouse, kids, and other relatives, which makes deployment sometimes incredibly hard. So let's make life a little easier for these men and women by giving them just one less thing to worry about. With that, Mr. Chairman, I yield back, and again, please excuse the confusion.
No, there's no confusion. We're all set. Good. Sorry, you heard the amendment. Any discussion? Hearing none, the vote is on the Rushenthaler amendment. All those in favor say aye.
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 Opposed, no?
No.
Opinion of the chair, the noes have it. You want a roll call vote?
Yes, Mr. Chairman, thank you.
Clerk will call the roll.
Mr. Hastings, Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
No.
Mr. Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin, no. Ms. Scanlon,
No.
Ms. Scanlon, no. Mr. Morelli,
Morelli's no.
Mr. Morelli, no. Mr. Desaulniers,
No.
Mr. Desaulniers, no. Ms. Ross,
No.
Ms. Ross, no. Mr. Cole,
Aye.
Mr. Cole, aye. Mr. Burgess, Mr. Eschenthaler,
Aye.
Mr. Eschenthaler, aye. Mrs. Fishbach,
Yes.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 8 nays.
The amendment is not agreed to. Further amendments?
Mr. Chairman.
Mr. Rushenthaler.
Thank you, Mr. Chairman. I have an amendment to the rule to make an order, Amendment 35 to HR 8, which again is offered by my good friend and colleague from Florida, Mr. Stubbe. This amendment adds a new exemption to the background check requirement, allowing the transfer of a firearm to an individual who has a valid state-issued permit to purchase or license a firearm. A permit to purchase or license to own a firearm. Mr. Chairman, while the requirements vary state to state, most often individuals who possess a valid permit must complete an extensive application process. They have to have a background check, they have to pay a fee, and a lot of times they have to go to a gun safety course. These individuals have proactively taken steps to show their ability to safely possess a firearm, and it makes sense that they would be exempt from transfer requirements. And with that, Mr. Chairman, I thank you and I yield back.
Thank you very much. You've heard the amendment. Again, we're trying to close loopholes. This sounds like it's trying to create yet another one, but in any event, is there any discussion? Hearing none, the vote is on the Rushenthaler amendment. All those in favor say aye.
Aye.
Opposed, no. No.
No.
Here, the noes have it. Would you like a roll call?
Yes, Mr. Chairman, I ask for a recorded vote.
Clerk will call the roll.
Mr. Hastings, Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
No.
Mr. Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin, no. Ms. Scanlon,
No.
Ms. Scanlon, no. Mr. Morelli,
Morelli's no.
Mr. Morelli, no. Mr. Desaulniers,
No.
Mr. Desaulniers, no. Ms. Ross,
No.
Ms. Ross, no. Mr. Cole,
Aye.
Mr. Cole, aye. Mr. Burgess, Mr. Eschenthaler,
Aye.
Mr. Eschenthaler, aye. Mrs. Fishbach,
Aye.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 8 nays.
Amendment is not agreed to. Further amendments?
Mr. Chair, I have an amendment.
Fishback.
Mr. Chair, I have an amendment to the rule to make an order amendment number 52 to HR 842 offered by Mrs. Fox of North Carolina. This amendment requires unions that have had at least one president or vice president convicted of a felony related to financial malfeasance with respect to the union within the past 3 years to file more detailed financial disclosures with the Department of Labor's Office and Labor Management Standards. Mr. Chair, this common sense amendment simply adds transparency for union members with respect to their union dues. Such calls for both accountability and transparency should not be a partisan issue. Union members deserve to know if their union leadership have failed to exercise appropriate financial controls and be held to a higher standard of disclosure based on the past actions. This amendment simply calls for transparency in such scenarios. Thank you, Mr. Chair.
Thank you very much. You heard the amendment. Any discussion? Hearing none, the vote is on the Fishback amendment. All those in favor say aye.
Aye.
Opposed, no. No.
Oh.
Opinion of the chair, the noes have it. Would you like a roll call?
I request a recorded vote, Mr. Chair.
A recorded vote has been requested. Clerk will call the roll.
Mr. Hastings, Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
No.
Mr. Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin? No. Ms. Scanlon?
No.
Ms. Scanlon? No. Mr. Morelli?
Mr. Morelli's no.
Mr. Morelli? No. Mr. DeSaulnier?
No. No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Mr. Reschenthaler?
Aye.
Mr. Reschenthaler? Aye. Mrs. Fishbach?
Aye.
Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk, report the total.
3 yeas, 8 nays.
The amendment is not agreed to. Further amendments.
Mr. Chair, I have an amendment.
Ms. Fishbach.
Mr. Chair, I have an amendment to the rule to make an order amendment number 32 to HR 8 offered by Mr. Shabbat of Ohio. This amendment adds a new exemption to the background check requirement, allowing a transfer of firearms to or from a museum or historical display. Thank you.
Thank you very much. You heard the amendment. Any discussion? Hearing none. The vote is on the Fishbach amendment. All those in favor say aye.
Aye.
Opposed, no. No.
No.
No.
Opinion of the chair, the noes have it. Would you like?
Chair, I request a recorded vote.
A recorded vote has been requested. Clerk will call the roll.
Mr. Hastings? Mrs. Torres?
No.
Mrs. Torres? No. Mr. Perlmutter?
No.
Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon?
No.
Ms. Scanlon? No. Mr. Morelli?
Morelli, no.
Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Mr. Reschenthaler?
Aye.
Mr. Reschenthaler? Aye. Mrs. Fishbach?
Aye.
Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk, report the total.
3 yeas, 8 nays.
Amendment is not agreed to. Are there further amendments? That, no other amendments? Okay. So if not, then the vote now is on the motion from the gentlewoman from Pennsylvania. All those in favor say aye. Aye.
Aye.
All those opposed say no.
No.
Chair, the ayes musically have it. So,
Oh, well, Mr. Chairman, we would certainly dispute that. We were much more unified, much more in tone. I think we clearly won the contest, if not the vote, but I will ask for a recorded vote, Mr. Chair.
the clerk will call the roll.
Mr. Hastings? Mrs. Torres?
Aye.
Mrs. Torres? Aye. Mr. Perlmutter?
Aye.
Mr. Perlmutter? Aye. Mr. Raskin?
Aye.
Mr. Raskin? Aye. Ms. Scanlon?
Aye.
Ms. Scanlon? Aye. Mr. Morelli?
Morelli is aye.
Mr. Morelli? Aye. Mr. DeSaulnier?
Aye.
Mr. DeSaulnier? Aye. Ms. Ross?
Aye.
Ms. Ross? Aye. Mr. Cole?
No.
Mr. Cole? No. Mr. Burgess? Mr. Reschenthaler?
No.
Mr. Reschenthaler? No. Mrs. Fishbach?
No.
Mrs. Fishbach? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk, report the total.
8 yeas, 3 nays.
And the motion is agreed to, and Mr. DeSaulnier will be carrying it for the Democrats.
Well, Mr. Chairman, I'm delighted to tell you that Ms. Fishbach will be carrying for the Republicans. It'll be her first appearance on the on the floor representing the Republicans in a rule debate.
Well, let me just say that to Mr. DeSaulnier and Ms. Fishbach that we expect the rule to be on the floor today around 5 or 5:15.
Wonderful,
So
thank
just
you.
I'll give you that. And then I just want to let everybody know we're still awaiting the Senate to provide us with what they did on the American Rescue Act. So we could possibly meet tomorrow, but as soon as we get an indication of when the paperwork will get here, then we will let you know. So, but that's the other thing that we're waiting for. So, having said all of that, it's great to be with everybody, and the Rules Committee stands adjourned.